Good morning, everyone. We are on the record in case number 2024-00354, electronic application of Duke Energy Kentucky for an adjustment of electric rates, approval of new tariffs, approval of accounting practices to establish regulatory assets and liabilities, and other relief. My name is Angie Hatton. I'm chair of the Kentucky Public Service Commission. With me today is Mary Pat Regan, commissioner. And I'd ask everyone to turn their phone on silent if you haven't already, or turn it off. And for those on video conferencing, please keep your mics on mute. I don't know if they've actually joined us yet. I may save that for when they actually join us. Okay. At this time, we'll have entry of appearance of counsel.
Thank you, Your Honor. On behalf of Duke Energy Kentucky, I am Rocco D'Ascenzo, Deputy General Counsel. My business address is 139 East 4th Street, Cincinnati, Ohio. Appearing with me in this hearing are Larissa Vaseman, Liz Brahma, and Val Herring. Liz and Val are with the Taft Law Firm.
Good morning. And for the Attorney General's office.
Good morning. Angela Goad and Tolan Lacey for the Attorney General's office.
Good morning. For the interveners, Kroger.
Good morning, Your Honors. Kurt Bain appearing on behalf of the Kroger Company.
And for Walmart.
Good morning, Your Honors. Carrie Grunman in the law firm of Spillman, Thomas & Battle on behalf of Walmart, Inc.
Good morning. And for Commission staff.
Good morning, Chair. Wright Williams, on behalf of Commission staff, also Ben Bellamy, Michael Crum, and Ellen Fauser are warming.
Okay. I have been advised that public notice has been given and filed into the record. Is that correct?
Yes, public notice was published for May 6th to 9th, filed into the record yesterday, May 20th.
Okay. And other than a number of confidential treatment motions, any other motions pending at this time?
I don't believe so, Your Honor.
All right, thank you. All right, let's move to the public comment portion. I'm told that no one has requested permission to give public comment online, but I'll see if anyone in the room is here for the purpose of giving public comment. Seeing no one coming forward or raising their hands, I will say that anybody who does wish to provide public comment may do so by following the instructions that have been posted on our website for at least the past 24 hours, or by submitting an email at psc.comment@ky.gov. And I believe we are now ready to move on to presentation of evidence, unless anybody else has anything at this time, any motions? All right, call your first witness.
Thank you, Your Honor. On behalf of Duke Energy Kentucky, we call Amy Spiller.
Good morning.
Good morning.
Please raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please tell us your full name and business address.
Certainly. My name is Amy Spiller. My business address is 139 East 4th Street, Cincinnati, Ohio, 45202.
Thank you. Councilman Lass.
Thank you, Your Honor. Good morning, Ms. Spiller.
Good morning, Mr. D'Ascenzo.
Would you please state your position with the company for the record?
Certainly. I am the state president for Duke Energy Kentucky and its parent, Duke Energy Ohio.
And did you cause to file testimony and responses to data requests in this proceeding?
I did.
And do you have any changes or corrections to any of that information?
I do, to my testimony as well as one discovery response.
Would you please walk us through those edits, please?
Certainly. On my direct testimony that was filed December 2nd, 2024, if we could turn to page 8. On line 5 of that page, there is a random letter T that simply needs to be deleted. That is a typo. On line 6, there is also at the end of the sentence that ends on that line an extra space after 2010 and before the period. So some minor nits, if you will, to be corrected. And then Mr. D'Ascenzo, in respect of the Attorney General's discovery response, our response to the Attorney General's data request 01-011, Part A. There is in there a reference to my testimony cited as pages 14 to 19. That actually should be pages 12 to 14.
And are those the only edits that you have?
Yes, sir.
So with those edits, if you were asked the same questions in your testimony and in response to data requests today, would your answers then be the same?
They would.
And is it your intent to have that information admitted into the record of this proceeding?
It is.
Thank you. Your Honor, the witness is available for cross-examination.
For the Attorney General's office?
Yes, thank you, Chair. Good morning, Ms. Spiller.
Good morning.
Duke Kentucky originally requested a rate increase of approximately $70 million in the pending rate case, correct?
That is correct.
And based upon the revised rate increase as filed in the rebuttal testimony, Duke Kentucky is now requesting an approximate rate increase of $69.987 million. Is that correct?
I believe that's correct. Yes, ma'am.
And according to the pending application, Duke Kentucky's last electric rate increase was granted by the commission in October 2023 and then amended on rehearing in July 2024. Is that correct?
Yes.
And if Duke is granted a rate increase in the pending case, it will represent the fourth rate increase for Duke Kentucky's electric customers in approximately the past 7 years. Is that correct?
I believe that's correct. Yes.
And do you recall in discovery the Attorney General asking if Duke Kentucky was aware of the poverty rates that exist in the Duke Kentucky service area, with the highest poverty rate being in Pendleton County at 13.2%?
I recall the discovery request. Yes.
And is it correct that based upon Duke Kentucky's original requested rate increase of approximately $70 million, the average residential customer's bill will increase by almost $20 a month?
I have not done that calculation, but subject to check. I would trust your math.
Would you agree that this requested rate increase can pose financial hardships on Duke Kentucky's customers, especially those who already live in poverty?
It may.
Thank you, Ms. Miller. I have no further questions.
And does it matter to the interveners which of you goes next? Have you talked about that?
No.
There won't be fist fights?
No preference.
Okay, so, Mr. Bain,
No questions, Your Honor. Thank you.
and Ms. Graham.
Just briefly, good morning, Ms. Spiller, how are you?
Good morning. I'm fine. How are you, counsel?
I'm doing well. So you serve as sort of the overview witness in this case, introducing the other witnesses and describing the overall request from the company in this case.
That's correct.
Okay. And I know at page 3, lines 9 through 10 of your direct testimony, you state that, you know, in addition to providing an overview, you are also supporting sort of the reasonableness of the company's request in this case. Do you see that?
I do.
Are you in any way supporting the calculations and underlying methodology upon which the ROE proposed in this case is based?
I was not counsel directly involved in calculating that ROE. I certainly believe that the company's request is reasonable.
Okay. And are you aware of the returns on equity that have been awarded to other sister companies of Duke Energy Kentucky?
Are you speaking of our affiliates in other jurisdictions?
That's correct.
I'm generally aware, yes.
Are you aware as to sort of if you were to compare, if the company were awarded the 10.85% ROE, I believe that it's requested in this case, as compared to other Duke Energy Kentucky affiliates, how that would compare?
I don't have those other ROEs committed to memory.
Your Honor, can I mark an exhibit?
Yes.
I will state for the record that this is the company's response to the Attorney General Discovery Request 1-136, and it's attachment 1.
Is this already in the record, yeah?
It is, so I don't know that we need to mark it, unless it would be your preference for ease of the record, but I can just pass out copies if that would be helpful.
I will mark it as Walmart's one.
Okay.
Sorry.
Thank you.
Your Honor, I would like to object to this document as to relevance. The company did provide this in discovery, but with an objection as to the relevance to this proceeding. So I would just like to note that, please.
Your response.
Yeah, I mean, obviously, obviously, the commission's job here is to determine a reasonable ROE for the company. I think that there are multiple, whether it's the CAPM or the DCF or comparison to other companies, the commission has wide discretion to consider evidence that is relevant to the reasonableness of the company's ROE. And I certainly think from the context of competing for capital, it certainly matters how Duke Energy Kentucky may compete as among other Duke Energy affiliates for capital from corporate parent as necessary. So I think that bears upon a comparison as to how other Duke Energy affiliates, what their return on equity is.
I do think I have discretion to allow it. And also, anything that's already in the record, commission's already seen, so it's like there's gonna be a jury that would be separate and seeing something we haven't already seen, so, I'll overrule that objection.
Ms. Spiller, do you see here, this listing of Duke Energy affiliates and their ROE along with the date when those, decisions were issued?
I do.
And do you agree, whether you remember specifically or subject to check, that these are the currently authorized ROE for these various company affiliates?
I don't believe that all of these are necessarily the currently authorized. Our sister utility in Indiana had a rate case subsequent to that 2020 date, I believe.
Do you know what the ROE was for Duke Energy Indiana?
I do not offhand.
Okay. But other than the Duke Energy Indiana, do the results seem accurate to the best of your knowledge?
To the best of my knowledge, both with litigated and settled outcomes.
And I just note here that the highest ROE that I see is for Duke Energy Florida. Do you agree with that at 10.3%?
I see that pursuant to a settled outcome.
And if a 10.85 were awarded in this case, it would be 55 basis points above the highest ROE awarded to any Duke Energy affiliate.
That math is correct, yes.
And then can I ask you to turn briefly, are you familiar at a high level what I'm sort of calling the company's large load proposal in this case? To sort of impose specific tariff provisions on loads 20 megawatts and above?
Vaguely, but that question is better directed probably to Mr. Salyers.
I agree.
Yeah.
But I just want to focus on, can you take a look at page 8 of your testimony? Beginning at line 18, you talk about the Duke Energy Site Readiness Program. And then you discuss there a number of sites on lines 20 to 22.
Yes.
Are the sites listed there, the Amazon Air Hub facility in Boone, the Niagara Bottling, and is it Diversey in Kenton County, and the Southern Campbell County Industrial Site? Are those operational, and is the company providing a full electric load to those entities?
I do know that we are providing service to the Amazon Air Hub in Boone County near CVG Airport. The other two council that are listed in Kenton County, as well as the industrial site in Campbell County, I don't know today the current status of whether our service is being provided there.
And so let's talk about the one site, the Amazon Air Hub, that you've indicated you are providing service to. Do you know, and I'm happy to refer this to Mr. Salyers, but since you mentioned it, I'm starting with you.
Sure.
Do you know if, had the company's large load proposal been in effect at the time of this Amazon Air Hub taking service, whether it would have been subject to that tariff?
If I may rephrase your question, is the load larger than 20 megawatts?
That's correct.
I believe that their initial proposal for that site, council, was in excess of 20 megawatts.
Okay. And do you know whether the company, and by company I mean Duke Energy Kentucky, had any difficulty interconnecting that load because of the necessary upgrades or costs, et cetera?
I do not have that operational exposure.
And then I know, if we could turn over to page 20 of your testimony. You note on page 20 that you have invested $250 million in additional electric infrastructure at the top of line 1 since the
Yes.
last base rate case. When you indicate this $250 million in electric infrastructure, you go on to note at line 5 that Duke Energy Kentucky is experiencing significant development in your service territory in northern Kentucky. Is there a correlation between the $250 million, the substantial economic development, and projects like the Air Hub project that we just discussed in Boone County?
There is certainly a correlation between the $250 million in investment in our electric infrastructure that we have made and the growth and development that we see in northern Kentucky. Boone County remains one of the fastest growing counties within the Commonwealth. That development, I would say, council, is very diverse. So some of the investments we are making are to support our current obligations as well as anticipated future obligations. I don't know that I would necessarily say those investments are part and parcel or specific to customers such as the Amazon Air Hub.
Okay. And so to the extent, right now, regardless of whether the commission were to approve or disapprove this sort of large load amendments to existing tariffs, the company already has the ability to engage in special contracts with customers if they're going to cause the utility to incur substantial costs. Isn't that fair?
We have the opportunity for special contracts, yes.
Thank you. Those are all the questions I have.
Thank you.
Staff?
No questions from staff.
Commissioner Reed?
Good morning.
Good morning.
Just to follow up on the question regarding investment. The large load that you currently have, I would assume is under a special contract or something like that. Do you see, or do you have signed contracts with other large investments coming into your territory?
Commissioner, as we approach economic development, we can have agreements with prospective customers, whether new customers or customers that are looking to expand, that allow us to go through a due diligence period with them so that they can understand what facilities, what infrastructure currently exists, what infrastructure may be needed to serve them on their timeline. That is typically a step in the process of the economic development activity in which we are involved. I am not aware today of a signed contract that is committing a customer to locating or expanding in Kentucky, certainly on the scale that we have been talking about this morning.
Okay. And then just a question on the increase, that'll be, ratepayers will be hit with about $20. Are there any plans to do some type of corporate help fund with people who maybe can't afford for that increase to happen?
Commissioner, I appreciate that question, and I can assure you that we think about assistance for our customers every single day. As I described in my testimony, there are different programs that we have available for all of our customers, certainly focusing on our customers who may struggle more financially. And as I think of our residential customers per se, we have our Share the Light Fund. It is a fund that is built up, if you will, by shareholder contributions, by employee and customer contributions, as well as additional corporate matches. So those are dollars that are available to qualifying customers during particular times of the year. So we think about January to April, and then I believe September to December, when some of those bills may be more challenging for customers. So we have our Share the Light program. We have our Home Energy Assistance Program. We are very involved with the Northern Kentucky Community Action Agency with respect to connecting customers in need with federal assistance dollars. So I think of LIHEAP in that instance, and a very strong partnership in Northern Kentucky to make sure our customers are aware of those assistance dollars and that we're connecting them to those resources as efficiently as possible. And in that regard, as Mr. Cawley can further elaborate, we have an agency portal now. So within our systems, we have the ability for agencies to more readily identify and pledge dollars against customers' accounts. We work with people working cooperatively with respect to energy efficiency, home weatherization, and those projects and undertakings that will make people's properties more efficient in respect of energy consumption, because we appreciate it's two factors, right? It is the cost of the service as well as the amount of service that is being consumed at a particular location. So we work hard with organizations such as PwC for energy efficiency. And our outreach continues. We understand, Commissioner, that customers don't always want to come to Duke Energy when they need assistance, when they are struggling to pay a bill. And so we partner with a diverse collection of agencies in the community to share information, whether it is information on budget billing, again, LIHEAP dollars, Share the Light. So we are looking to get the information out in ways that our customers individually choose to receive that information.
There has been discussion, and I know we're all operating in kind of this arena where we're not really sure what's gonna happen, but there's been discussion at the federal level of LIHEAP going away. Have you thought about how that would impact your lower income customers, and if there's any way that Duke Energy would fill in that gap if that does go away?
We have, our immediate focus, Commissioner, has been on engagement at the federal level. So through our colleagues in DC, there is engagement with lawmakers and policymakers on the criticality of LIHEAP. We are also part of an organization, I believe it's 14,000 members strong, advocating for the retention of those LIHEAP dollars. So that is our immediate focus and where the efforts have been directed.
Okay, thank you.
Good morning.
Good morning.
So speaking of collaboration with partners, and you said that you work closely with the community action agencies and such, and I can ask Mr. Sailors more about it, because I think it was addressed pretty heavily in his testimony, but Walmart's witness, Perry, had advocated for a group of stakeholders to be considered in your EV charging policy or plans. And I know that Duke objects to being told that they have to, but in what ways do you and can you work with stakeholders? That was very general.
No,
regarding
Madam-
EV in particular.
Madam Chair, I certainly appreciate that, and we have had regular conversation and collaboration with stakeholders in the area of EV charging infrastructure. We certainly appreciate that this is additional load that will come onto our system. and it may come onto our system in geographically defined areas. So it is important to understand what that load may be and when it may be coming onto the system, and can our system accommodate that load. I think there are also creative solutions that merit further evaluation, right? Are you going to have an entity that is going to bring all of their transit vehicles back to the same location and charge those vehicles at the same time every day of the week, right? That has a different dynamic and impact on the load than if we have an entity that is able to spread out the charging activity during certain periods of time. And so I think there is an opportunity to explore solutions. I
Time of
believe.
use, time of use restrictions, for instance, may be something that would need to get discussed.
I think there is an opportunity for that collaborative conversation. I think it's important that we're at the table early and maintain a seat at that table through the conversation. We are mindful that we don't want, for example, in an area, as I think of the CVG Air Hub, and all of the activity, the cargo activity that happens there, we don't want one entity to take that reserve capacity for their charging needs and leave their neighbors without that similar access. So again, I think it is important that we sit down with those who are interested in EV charging infrastructure to understand their timelines, their demands, and their needs.
I think of Duke's service territory as probably the area in Kentucky that may be the most or the soonest affected by the need for EV chargers because of all of the carriers and transport and the new load that's coming on. So it does seem that will affect maybe Duke's territory more quickly than others. Have you had someone from the state transportation cabinet reach out to talk to you about the state's plans to have the public EV chargers every 50 miles down the highway and all that sort of thing?
We were very involved with the Kentucky Department of Transportation as well as the Energy and Environment Cabinet with respect to those plans and the deployment of those federal dollars. And it was quite prescriptive at the beginning with respect to what interstates on which that charging may first be made available. But we have been very involved, as well as with OKI, which is a metropolitan planning organization responsible for northern Kentucky as well as parts of Indiana and Ohio.
So the state transportation cabinet's aware of the energy needs of your customers and the possible parameters that they'll need to work under?
Those conversations, Madam Chair, really involved around if you were to locate charging infrastructure at this particular location, what are the power needs to service that location? What may already exist? What may need to be invested in?
And then totally switching gears, with regard to terminal net salvage on eventual retirement of coal-fired power plants. That is a tough issue in Kentucky. The new statute is very difficult to meet those standards, probably by design. Who is your best witness to talk to me about details of that?
We have, Madam Chair, several witnesses who can touch on the terminal net salvage. So witness Matt Columba will talk about our integrated resource plan. Sarah Lawler can also talk about the rates and the policy issues. Bill Luke, one of our witnesses, can speak to you about the operation of the East Bend coal plant. I appreciate that there are also legal issues wrapped up in that in respect of the application of the statute.
Yeah, and that rebuttable presumption. Yeah,
Yes, to the extent that the rebuttable presumption does apply with respect to terminal net salvage.
We don't want to have an absurd result, but it is very difficult to contemplate that yet. Duke may be the first one who's really had us look at it in the way you're having us look at it. So, anyway.
I do not agree that, or I'm sorry, I do agree that it is a difficult decision with the way the statute was drafted. I think there is the interpretation that that statute is triggered when the utility is seeking permission to retire a generating asset. And then the rebuttable presumption and the obligation to overcome that presumption again is triggered when the utility is asking to retire. Here, we are not asking, within this case, to retire the East Bend Power Plant. We are certainly looking to restore accounting practices to ensure that when East Bend is eventually retired, we don't have a financial burden that is inappropriate or overwhelming for future customers.
And I appreciate that the statute was enacted after your last rate case had already been filed. So we've addressed it once, and we're gonna need to address it again. It may just be that eventually the court has to tell us, because certainly there's an interpretation of that statute that doesn't allow us to begin allowing, accounting practices to make sense.
Right, unless we overcome the presumption, as I believe our witnesses will advance in this proceeding.
All right, I think that's all the questions I have. Redirect?
Yes, Your Honor, just a few questions. Ms. Spiller, following up on the chair's questions about the rebuttable presumption, and she had asked about what witnesses the company has, and you identified several. Do you know whether the company also has a witness to talk about the dispatchability of generation in the markets and who that might be?
How could I forget Mr. John Swez? Yes, we do.
Thank you. And also, do we have a witness that can also speak to the calculation of terminal net salvage as it relates to depreciation expense?
I'm sure we do. I know our depreciation witness is Mr. John Spanis.
Thank you. Going back, Ms. Spiller, to some questions from the Attorney General. Counsel for the Attorney General had discussed the number of electric rate increases the company has had in the last 7 years. Do you recall those questions?
I do.
In your testimony, do you talk about the developments that have occurred since the company's last rate case that are driving this application?
I do.
And can you identify where in your testimony that might be?
Let me find that, Mr. D'Ascenzo. I mean, as I look through my testimony, sir, I would certainly remind that, as noted and as I was asked, we have invested $250 million in new electric infrastructure, and that is the new infrastructure to continue to provide reliable service to our customers. But we also need to maintain and invest in our existing infrastructure, whether that is the transmission and distribution or generating assets that serve our customers. And we are doing so in a way that we are endeavoring to hold down costs where we can, but those are the bulk of our investments that we're making for our customers.
Thank you. Do you still have in front of you the exhibit that Counsel for Walmart passed out, AGDR 01-136, Attachment 1?
I do.
And is it your understanding that this document identifies affiliates of Duke Energy Kentucky and their authorized ROEs?
As of a date and time, yes, sir.
Can you, do you know whether there are both gas and electric utilities identified here?
There are.
Are you able to identify which of the affiliates here are natural gas utilities?
Certainly. Well, we have Duke Energy Ohio has a gas, let me rephrase. Duke Energy Kentucky and Duke Energy Ohio are the only dual service utilities within the Duke Energy family. So you have ROEs for both the electric and gas businesses within Duke Energy Ohio listed. Then the other Duke Energy entities that are listed on this document, Indiana, Carolinas, Progress, Florida, those are all electric only public utilities. The Piedmont entities listed, the last two there, are only natural gas providers.
Thank you. And referring to Duke Energy Ohio as an electric utility, do you know whether Duke Energy Ohio owns and operates generation to serve its customers?
It is not permitted to by law.
And how would you describe Duke Energy Ohio as an electric utility?
a transmission and distribution utility.
Thank you. And do you recall questions from counsel for the Attorney General about the effective dates of Duke Energy Kentucky's last electric rate case?
I do.
Do you recall what those dates approximately were?
I know that the original order was issued in October of 2023. Then there were some matters raised on rehearing, and then the order followed that.
What, I think you said October of 23. Was it October of 22?
Now that you say that, I don't recall, but the docket certainly would confirm that, sir.
Thank you. So let's assume that it was in, do you know when Duke Energy Kentucky, let me strike that. Duke Energy Kentucky had filed for rehearing, did it not?
It did.
Do you happen to know when approximately that would have gone into effect?
I do not.
Okay. No further questions, Your Honor.
Okay. And recross for the Attorney General's office.
Yes, I was just going to, on that last question, I was going to refer Duke to their application, paragraph 6. That's what I have in my notes. Do you have that, Ms. Spiller?
I do not, counsel, have the application.
Mr. DeCenzo, is it possible to give Ms. Spiller the application?
Yes.
Is that the entire record in this case?
Basically.
Yes.
I've never seen it. Presented. I maybe want to put it just so that folks understand what our staff does here and.
If it's easier, I can read the paragraph into the record, but we can also wait if you would prefer to.
I have it as tab 1. If you just want
To
the
see the
smallest part of the application, is that what you're
Just
doing?
paragraph 6 is all I was gonna ask her to read into the record.
Be happy to provide you my copy if you'd like it.
Thank you. Thank you, Nina.
Just let me know when you're there, please.
I do have paragraph 6 in front of me. Yes, ma'am.
All right, just to clarify the dates of the, the last rate case order and rehearing order, can you please read paragraph 6 into the record?
Certainly. Duke Energy Kentucky's present electric rates and charges, which are based on costs forecasted during the 12 months ended June 30, 2024, were authorized by this commission by order dated October 12, 2023, and as amended on rehearing by order dated July 1, 2024, and by order entered nunc pro tunc dated July 10, 2024, in case number 2022-00372.
Thank you, Ms. Spiller. Do you have any reason to believe this is incorrect in any way?
I do not.
Thank you. I have no further questions, Chair.
Okay, and recross by Mr. Banks,
No questions, Your Honor, thank you.
Ms. Grumman.
Yes, briefly. Ms. Spiller, Chair Hatton asked you a few questions about sort of stakeholder engagement, but in that context referenced Walmart's recommendation regarding EV rate design. Do you recall those questions?
I do recall the questions.
And I just want to level set to make sure that we're all on the same page, because in response to those questions, you made some comments about fleet charging. Do you recall that?
I do.
Are you aware that in this case, what Walmart has requested that the company put forward is rate design for public-facing EV charging?
I have not read the testimony of your witnesses. I apologize.
That's okay. But you agree with me that public-facing EV charging is generally, in the EV industry, considered distinct from fleet charging. Do you agree with that?
I would say that those are two different applications of EV charging.
And public-facing charging, can we agree that a definition of that is a charging station open and available to the public?
Typically for a cost.
I agree, typically for a cost. And by contrast with fleet charging, that is typically an on-site charging station that an entity uses to charge its own vehicles.
Correct.
Okay. And so, understanding those distinctions, do you agree that it would be easier to impose time of use rates on fleet charging? Because the customer itself has complete control and access over its own use of those chargers.
It's easier in what way, counsel?
Well, in this case, that if the customer owns the chargers to charge its fleet, and the vehicles being charged at that station are the customer's own fleet of vehicles, then in that case, the customer is completely in control of when it elects to plug those vehicles up to its fleet chargers. Do you agree with that?
I would agree with that statement.
And so in that case, the one entity that needs to be controlled and managed via their charging could respond to time of use price signals. Do you agree with that?
They could respond, yes.
Compare that to public-facing EV charging that is open and available to the public. In that case, would you agree that it can be more complicated to use time of use rates for public-facing EV charging, where the customer with the charger has some or little to no control over when their customer elects to charge at that public-facing charging?
I don't know that it's more complicated per se, in that the owner of that public-facing charging infrastructure can determine what the costs are to charge at a particular moment. It may dissuade some activity on the part of someone who wants to use that infrastructure, but I don't know that it's necessarily more complicated.
Well, if the goal of putting in a charger is to have it be used, it's very important that the individuals using it understand what it would cost them, correct?
I think that's true with any service, yeah.
Thank you, those are all the questions.
Thank you.
Okay, and staff. Is Ms. Spiller gonna be the main witness that we don't excuse?
Your Honor, if you would like Ms. Spiller to stay, I believe she's able to.
I would like someone to be the
Okay.
main witness as sort of a catch-all.
Sure.
So if you're volunteering Ms. Spiller as tribute, then
Yes, Your Honor.
I won't be able to excuse.
Madam Chair, I am happy to stay with you for the duration.
Thank you. And please call your next witness, sir.
Thank you, Your Honor. For our next witness, we call Matthew Kalimba.
Good morning, Mr. Kalimba. Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. Tell us your full name and business address.
Sure. Matthew Kalimba, 525 South Tryon Street, Charlotte, North Carolina.
Okay. Counsel, you may ask.
Thank you, Your Honor. Mr. Kalimba, would you please state your position with the company for the record?
Vice President of Integrated Resource Planning.
And Mr. Kalimba, did you cause to file testimony and data response answers in this proceeding?
I did.
Do you have any changes or corrections to any of that information?
I do have one change to the testimony. Page 9, line 4. There's an extraneous phrase in there that starts with an open parentheses, 22% by 2035, and then close parentheses. That should be removed.
Is that your only edit?
Yes, sir.
Thank you. With that change, if you were asked the same questions today, would your answers then be the same?
They would.
And is it your intent that this information be admitted into the record of this proceeding?
Yes.
Thank you. Your Honor, the witness is available for cross-examination.
Okay, Ms. Go.
Thank you, Chair. I only have one question for you this morning. Duke Kentucky's parent company, Duke Energy, has publicly pledged to retire all coal plants by 2035 pending regulatory approval. Is that correct?
It's a goal, not a pledge.
And when you say goal and not a pledge, Can you expound on that?
Sure. It's, our goal would be to retire coal by 2035. However, we understand that across the multiple jurisdictions that we operate in, there are different regulatory requirements and legal requirements. And so to the extent that it's in the best interest of customers and that we maintain coal beyond 2035, we would do that.
Thank you. I do not have any further questions.
And Mr. Bain?
No questions, Your Honor, thank you.
Ms. Cronin?
Mr. Colombo, it's just nice to see you outside of Raleigh, but otherwise I have no questions.
Seth?
Yeah, we did have just a few questions. I was looking at page 12 of your direct testimony, and you indicated in a scenario without EPA CAA 111, which that's the new greenhouse gas rules proposed under the previous administration, is that correct?
That's correct.
And I guess first question is, I guess with the change in administrations, do you all anticipate either a pushing back of that or potentially a removal of that requirement?
The current administration is undertaking activities to attempt to repeal that.
Okay. The question I had in the preferred portfolio anticipated the EPA CAA 11, and the portfolio that was chosen under that scenario was converting East Bend to natural gas in 2030 or by 2030 and then retiring it in 2039. Is that correct?
It was correct, or it was not a full conversion, it was a dual fuel, converting
Okay,
to dual
okay.
fuel operation, yes, sir.
But on page 12, I think you indicated that the IRP analysis in a situation without the new greenhouse gas rules, that retiring East Bend in 2035 would be the most economic option. I guess I had a question about it. If converting East Bend is the more economic option in the face of the greenhouse gas rules, how is, without the greenhouse gas rules, why is it cheaper to retire it earlier?
Sure. So primarily, you would not, under the greenhouse gas rules, we're required to meet the statute, and so, or meet those rules, and there's limited ways to meet those rules. And what we found was that the most economic option was to do the DFO conversion under EPA 111. Without EPA 111, there aren't requirements to retire by a certain date. There aren't requirements to do conversion if you don't retire. So it's a separate analysis looking at a world with 111 versus a world without 111. So if we focus on a world without 111, what we see is that if we continue to operate East Bend beyond 2035, costs continue to rise until you get out into very late into the 30s, and there's some flipping there that we can discuss. But primarily, in the late 30s, you start to run into a lot of issues with maintaining equipment at East Bend. You start to run into potential reliability issues at East Bend as the asset's now, pushing 55, nearly 60 years old at that point. So considering the costs and the risks of operating beyond 2035, we believed that the portfolio for retiring East Bend in 2035 was the best option for Kentucky customers.
When under the greenhouse gas rules, when you convert to the dual fuel, is there a capacity or a capacity factor limitation on that converted unit?
There's a capacity factor on limitation on how much gas, or not a limitation, but you must burn at least 40% natural gas in that case. And the reason that's really important is because now you've got two fuels on the unit, right? So if the coal handling facilities that are aging at that point break down, for lack of a better term, you have another fuel to be able to operate the unit and continue to maintain reliable operations for the customer. So that's why doing the DFO conversion allows you to operate beyond 2035 in those instances.
I guess my question though, with the, and I'm trying to recall the rules, but with the, like the new combined cycle units, the greenhouse gases would impose a specific capacity factor limitation on them. Is there a similar capacity factor limitation on that converted unit, or is there no limitation?
There's no limitation on the full
Okay.
unit.
Looking at the chart you have on page 13 of your testimony,
Yes,
and you kind of alluded to it a second ago, you know, this is a chart showing without the new greenhouse gas rules and the cost of various portfolios. I guess that's the annual cost, correct?
that's the cumulative cost over time, yes.
Okay, so that's the cumulative
Cumulative.
cost over time.
Yes, sir.
I guess my question would be, what's the driver of the, you know, after about 2036, it looks like the other potential portfolios start to increase in relative cost. What is the driver of that?
Sure. So the primary driver for why you start to see that change and why there's actually a crossover in 2038, 39 timeframe is really driven by the market and what we calculated to be the normal market prices or the market prices that we could be purchasing power at from the PJM market as part of our modeling effort, as well as what the assumption is around coal and gas prices. So when we develop an IRP, we're using a lot of weather normal, expected fuel prices, expected power prices, things that, you know, is our base assumption. So under that scenario, we showed that coal prices are essentially remaining flat while gas prices are increasing over time. And so what you see is a unit that had the ability to operate coal was going to perform better than a unit that didn't have the ability to burn coal. Additionally, you start to see the rest of the market is moving towards gas and renewables versus our portfolio. And so those market prices start to drop. And what you see is, particularly on the coal units, they start to stop running, essentially. And you're heavily reliant on the market at that point. So what's happening is you're getting essentially at least half of your power from the market in the late 30s. And it's simply a factor of what we're calculating the market to look like in that period. So there is significant risk in that, in which that portfolio, the one where we keep coal around until 2041 in particular, that unit that's only reliant on coal in a fading marketplace, that they all of a sudden are not going to be able to, we're going to be heavily reliant on the market, where those market prices might be increasing over time, or coal may not be available. So there's a really high risk in that portfolio. So even though the costs flip at that point in the late 30s, we still felt that the retirement in 2035 case was the best case for customers, because it starts to remove some of those market risks around coal availability.
But you said that part of the reason it's cheaper is because coal prices would be going down. Would that not reflect that there was ample supply?
No, so
Or that coal prices aren't going up as quickly as gas prices are going up? I'm sorry.
That's correct. So coal prices aren't going up as quick as gas prices, but it reflects that there's fewer coal plants in the marketplace, not burning coal. So which leads to another risk that we see, is that so as these other plants are retiring over time, you're losing a labor force, you're losing OEM equipment, you're losing all these folks that can actually work on coal plants, and you're losing the parts that are available for maintaining coal plants. And so you're running with this risk. So yes, the projection on coal prices are a supply-demand projection, but the issue is that the demand is dropping because coal plants are retiring over time, not because there's more coal available.
2030, in this scenario, or without the greenhouse gas rules, in at least a number of the instances, I guess there's one where you have, it's hard to see the lines because they kind of, do you know if there's anything in the record of this case
There is.
that has this broken out?
There it is. It's in response to staff DR, I believe 02008.
Thank you, I'll take a look at that.
Okay.
I guess the question is, it starts to flip around mid-2035. You said the market prices in all the scenarios, they're gonna be the same. You're projecting the same market prices for each scenario, correct?
That's correct. In
So-
the no 111, to be clear, in the no
Yes.
111 world, yes,
Yes.
we're projecting the market prices to be the same.
So the difference is gonna be how often the coal versus the gas units are dispatched.
Correct.
And then the capital costs associated with the various units, is that correct?
The capital costs and the ongoing operating costs of those units.
The non-variable costs that aren't associated with dispatching the unit.
Both the variable and the ongoing fixed and capital costs.
And then the capital costs start coming online for the other portfolios, I guess, in 2030 through 2036 for the CT, or the combined cycle.
The combined cycle in the retired by 35 case that you would start to see those coming on in 2036.
Yeah.
The
And then
other-
for the conversions, it would be 2030 for the conversion, and then 2039 for the CT.
So in the DFO conversion case, you start to see the capital costs for the new generation for the combined cycle coming on in 39. There are capital costs associated with the DFO conversion itself that are happening in 30 at East Bend.
Would you expect those lines, as you go out beyond 2042, because of the high capital costs for the new units, would you expect the present value revenue requirement for the retaining the East Bend unit to further diverge as you go out further into the future?
It's tough to say. At that point in 2041, you're going to see potentially a new unit come online in 2042, potentially a combined cycle come online. And it depends on if we were optimizing what that replacement generation would be, what would happen. Though they could diverge, but at that point you have, you're now going to have the higher capital costs for that new unit. But those, if it's a combined cycle, which I think it would be, you would have that higher capital cost for that new unit, so you would see a higher cost associated at that point. But then you've got two combined cycles that are running essentially in those two portfolios, and there really shouldn't be that much difference between the combined cycle that you put in 36 versus the combined cycle that you put in 42, at least in the operating environment out into the 42 and beyond.
And I guess I was actually anticipating a scenario in which East Bend, a decision has not been made as to what happens with East Bend in 2042. If it continued to operate beyond 2042, how would you expect the prices? Or did you all look at that?
We did not, however, what you would see is certainly higher costs at East Bend to maintain the unit at that point. And so there would become a point where it says you have to make the decision on, do those higher costs to maintain East Bend when it's 60+ years old outweigh the costs of and benefits of replacing East Bend with a combined cycle.
And did you all look at that?
No, the planning period we only looked at the planning period out to 42.
Okay. I'm a little confused, and this is just being unfamiliar, I guess, with all of the PGM rules, but you indicated that you're subject to, within PGM, a negative reserve margin of 6.1. Could you explain that?
I'm gonna try, and John Witness Swez might be able to add some more onto that. But PJM looks at the different operating regions within the marketplace and determines based on historical operations and the reliability of the units and how they've been operating, and assesses how much firm capacity is needed from each region to be able to maintain reliability across the PJM region. So when it looks at Duke Energy Kentucky and it looks at the load in the region, it says, okay, I need a little bit less firm capacity than what you're showing. So it shows a negative reserve margin, because it says you don't actually, at the point in time that they develop that, you don't actually need to be carrying, whatever, like a positive reserve margin, a plus, 10% reserve margin or something along those lines. It says carry a minus 6% reserve margin. So we're actually above reserves today by a fair amount.
Is that if you're an FF or an FRR entity, or is that if you're in RPM?
So we would use the same methodology to come up with what the required reserve margin is, whether we were in the FRR or RPM. And because again, Witness West might be a better witness for
I
this,
can
but
ask it.
there's a declining reserve margin curve in the RPM versus a flat reserve margin curve, and it's tough to know where you're going to be at on that declining reserve margin curve. So we would estimate that we'd be about the same point as that flat curve.
Is there any discussion in doing resource planning regarding whether or not state adequacy of service requirements would mandate a positive reserve margin even if PJM is allowing for a negative reserve margin to ensure that you're fully hedged against the market and can serve customers with your native load?
Yes, I think
with your native resources.
Yeah, and I think in the staff's report, you all suggested doing additional resource adequacy analysis specific for Duke Energy Kentucky, and that is something that we can do and look at. We've looked at that in a couple of the other regions, and we think we have a methodology for better understanding what it looks like just for Kentucky outside of the PJM market. So it's one thing that we're going to be looking at for the next IRP.
When you have peak load, say in the Kentucky region, how does power get, what are the limits on, I guess, transfers, between Kentucky and other either zones or other portions of the Duke zone outside of Kentucky? Are there limits on how much you can transfer?
So when we develop our power prices, which tells us the hourly power prices that we should be purchasing or that we can purchase or sell into the marketplace for long-term planning, it does see some, I don't want to say congestion, but it recognizes that the other parts of the marketplace might be have less demand or higher demand than what's happening in Kentucky. So you'll get some higher or lower prices across the Duke Energy Kentucky border with other regions that we're connected to. So we're sort of reflecting that within the IRP, but I don't know what the specific limits are for being able to import power or into our region.
And that's what I was wondering, like the physical limits to it.
Yeah, I don't know if there are specific physical limits. That might be a question for John Swez, or Witness Swez, but I'm not sure he'll be able to answer that either.
And when you looked at reliability for the IRP, the model, the resource assessment model that you ran just tested the various portfolios against the PJM reserve margin, is that correct?
That's how the model will, one of the things that it looks at when it looks to build new resources is or retire resources, are you staying above that PJM reserve margin?
Is there any other metric that looks at reliability as far as the resource assessment model? The one, I don't know if that's what you call it, the Encompass, do you call that the resource assessment model or?
Production and capital capacity planning model.
Okay.
But that is the only metric within that model that is available to us. There are other models that we're looking at to be able to use to assess metrics like loss of load expectation. So are you meeting a standard for reliability? And that's one thing we're going to be looking at in the future.
And have you, in the IRP, the last one, or in preparation for your testimony in this case, did you look at the loss of load expectations for the portfolio with and without East Bend with the CT unit, or I'm sorry, the natural gas combined cycle unit?
We don't have those tools available to us right now for doing that analysis within Kentucky itself, but, and so we did not look at that in this instance. What we relied on was PJM also provides not just the reserve margin, but they provide what's called a ELCC, so it's what's the capacity value that you should be giving towards a coal plant or a gas plant. So we use those values in our analysis.
You mentioned if there was a natural gas combined cycle unit that would go online, say 2042, in the scenario where East Bend operates until that point, that the capital cost for that natural gas combined cycle unit might be higher. How did, for the natural gas combined cycle units in the other scenarios, and I guess we'll just limit it, or with the other portfolios, in the no greenhouse gas rule scenario, I guess firstly, how did you determine the capital cost for the natural gas combined cycle unit, and then how did you escalate it through the years?
So first, a point of clarification, when I say that the cost would be higher, there's actually a slight decline curve on that we assumed or used based on EIA data for gas combined cycles. So on current dollar basis, the cost would be slightly lower in 2042 than 2036 for that combined cycle. So just want to get that right. But to answer your question, we work with third parties who provide us, based on what's happening in the marketplace at the time that we develop the capital prices, costs for these resources. And then we rely on the EIA puts out cost technology curves that we apply towards the costs from today and use those EIA cost curves to project out into the future what future costs might be. We also apply a standard or an inflation rate, and I think the inflation rate we were using at the time was 2.5%, long-term inflation rate.
So you said that it would be cheaper in 2042. Would it be cheaper applying both that EIA curve and the inflation rate?
It's pretty flat, but it is a slight decline.
Does it go up for a period of time and then drop down?
No, not in their current view, or in the last view that we had.
What year was that from?
Let's see, so we developed these curves that would have been early 24, but based on data from 2023.
Are you familiar with what's happening with respect to the natural gas combined cycle market?
I am, yes.
And are prices increasing or decreasing?
So they are increasing today, or they have increased. I don't know if they're increasing today, but they've certainly increased over the last 6 to 12 months, or perhaps even 18 months. But on a long-term basis, expectations are that, between efficiencies that the manufacturers will develop, that over time there should be a slight cost decline curve for the technology. Now, inflation, long-term inflation rates, I think they're holding steadily, at somewhere between 2.5% and 3% today or so. So, what's the long-term projection of inflation? And the IRP would use the 2.5% as the long-term.
So how many years? Obviously, it's hard to project markets out into the future, but obviously, well, I guess firstly, what is your knowledge of the extent to which they've been rising over the last year or two?
I think this would be subject to check, but I think we've seen an increase of, say, 30% over the last year or so.
And based on current information, do you have any idea as to how quickly or how long kind of that escalation in prices is expected to go on?
I don't have any information.
Okay. But eventually, it's anticipated that will level off and perhaps they'll start going down.
Sure. Again, it would be a supply-demand issue. There's a lot of demand for natural gas combined cycles and combustion turbines today, and so you would expect that either the market's going to catch up, or the manufacturers are going to catch up, or the market's going to cool off.
Yeah. So basically, everyone wants one now, and maybe they'll ramp up manufacturing, and then once that's ramped up, the price starts going down.
Yeah, perhaps that's right.
When you did the Encompass, I'll just refer to it as Encompass modeling, but did you set the retirement dates for East Bend in the model runs?
We did. We looked at several retirement dates, 32, 35, 41, end of 41.
Okay, so Encompass didn't dynamically select based on cost the retirement dates.
That's right. I did.
Okay. With respect to the IRP, and I apologize, I know this is in the IRP, I'm just trying to make sure everything's in the record here, but how did you, could you just give me just a really brief explanation of how load was projected for the IRP and whether it remained flat after a certain period or, when it increased? And if you can refer to me something in the record, that would be fine.
Yes, I should be able to do that. So in the Appendix B, starting on page 66 of the IRP, we get into the electric load forecast
Okay.
procedure and then methodology for developing load forecast, and then what the projections are over time. And I believe there was a slight increase, or there was an increase over time in demand for that.
Well, I'll just refer to that.
Okay.
then. I didn't have any other questions. Thank you very much.
Commissioner Reagan?
I don't have any questions.
Good morning.
Good morning.
I know you're an engineer and not necessarily a lawyer. Are you also a lawyer?
I am not.
Okay. I do not mean to be asking for legal conclusions, so I will try very hard not to. But your testimony does go into detail about the statute, the rebuttable presumption, et cetera. You can absolutely tell me if I'm asking you something that is trying to be too lawyerly, and I'll accept that as an answer. But I do want a record to be as complete as possible, especially in this area. First, I'll ask a follow-up to something that Mr. Bellamy just asked. So even with PJM's new ELCC requirements, Duke still has a negative 6.1% reserve margin.
That's the minimum that we must maintain.
Okay.
And we're maintaining, it's in table H3 in the IRP, but it's well in excess of that. We don't get to a negative reserve margin
Okay.
until 39,
So
40.
lots of utilities are telling us that the new ELCC caused them to be short in their capacity expectations. Duke, that's not happening to Duke?
So we're looking at long-term planning, and then there's a short-term planning, like in for the next auction and what we need on the market. Again, Witness Wes can talk more about what we have available and how we're projected. But there are times in the short term where we may need to purchase capacity or go out into the market.
Okay.
But today, from a resource adequacy perspective, we have sufficient resources to meet the required reserve.
If you were more reliant on solar or wind, we would expect that to be a little different.
We would have to build a lot more solar and wind to get the same firm capacity that a combined cycle or a coal plant would provide.
And so as long as you're doing the dual firing, the DFO, we don't necessarily expect that would go down because your resource mix isn't changing as far as the ELCC.
Right, either DFO, a new combined cycle, or staying on coal. At this point, the ELCCs are pretty similar between all those resources, so you would expect that you would maintain.
Eventually, coal-fired power plants, we expect may retire, and maybe there'll be new technology by then to replace it, but we have to assume that if we're phasing out fossil fuels, that the reliability requirement is going to change.
I would expect the reliability requirement to change if we become more reliant on non-fossil, well, I shouldn't say non-fossil fuels, but intermittent resources.
Gotcha. That's how I should have said it. Okay. We are talking about DFO, dual fired, not converting completely.
That's correct.
Okay, even though we talked about DFO conversion a few times, we don't actually mean full conversion.
Right, we frame full conversion as natural gas conversion, and we frame dual fuel as DFO conversion.
Okay, is there ever a point when either East Bend or Woodsdale would be fully converted? Or is it just gonna be DFO and then retired?
It would either be coal and then retire, coal converting to DFO to retiring, but I do not envision us going to a full conversion at East Bend. Things can change.
Right.
But at this point, I don't
Things will
envision.
change every 15 minutes,
Unfortunately, yes.
as it seems to be this year anyway, so, yeah, that's some fun to your job. So, here we go. Let's dive into this rebuttable presumption. So you've made it clear, and Duke has made it clear in this filing numerous times that you're not at this point asking to retire either Woodsdale or East Bend.
Correct.
As far as the coal-fired capabilities. What triggers that? At what point? Do you know yet? At what point a specific occurrence or decision will trigger the need to actually file with the Energy Planning and Inventory Commission an application to retire?
So my understanding is that prior to filing a CPCN for replacement generation easement, so we would say we're gonna retire East Bend and we're gonna replace it with a combined cycle. Prior to filing that CPCN, we would have to file with the EPIC Commission notification, and then they would go through whatever they're doing for the 180 days or so, and come up with a report on their recommendation for whether or not we should move forward with that.
Prior to filing the CPCN for the replacement generation.
That's my understanding.
However, the statute, it's set out in full detail in your testimony. So 278, 264 specifically requires that you already have the replacement generation built and ready to operate. So how do we reconcile that?
Oh, so we can't retire, per this, the KRS 278.264, we cannot retire until that's constructed, until the new
Right.
generation's constructed. We wouldn't.
But you
seek-
can't ask to retire,
We can.
or you
a-
won't ask to retire until you filed a CPCN for the replacement.
We would ask we would ask to retire the unit pending the approval of a combined cycle generator through the EPIC Commission and then through the CPCN process. So in my view, the EPIC Commission is a prelude to the CPCN because it's gonna inform you on what their recommendation is around approving that CPCN.
So that's the way we'd thread that needle. That's the order things would need to be filed in.
I believe so,
Okay. And I'm asking you because I don't know.
yeah. So, right, no, that makes sense. We're not gonna begin construction on a unit until we have approval to begin construction on that unit, right? So we have to go through that process and acquire CPCN, and that CPCN, again, is informed by testimony that we'll file and information from the EPIC Commission. And that will inform it, and then we'll start construction, and while we're constructing, we're keeping East Bend running, and then that combined cycle comes online that's been approved, and then we retire East Bend, right there, then and thereafter.
I may have to go back and listen to this and write that down and make those, make that timeline in my head so that I can understand it. But, and I know I'm not the only one thinking about this. You're definitely not the only one thinking about this. This is all new in Kentucky. No one has filed any application to retire a coal-fired power plant at this point. And I don't think anybody wants to be the first one to do it. But someone will eventually have to. They're not gonna last forever, so. Some more questions here. Tell me what intergenerational subsidization is. Is that when the next generation of customers pays for a facility that they didn't get benefit of?
That's essentially correct, and there'll be other witnesses that we'll talk about as well, but with the, I think specifically for terminal net salvage value, the customers who are benefiting from the generation that's online today should be paying for the, in our view, paying for the full cost of that generation, such that when that generation is eventually retired and will be retired, there's going to be a new generator coming online. And customers that are around at that point should benefit and pay for that new generator. They shouldn't be paying for the generator that was just retired.
Okay, and you'd like to do that through the net salvage? It doesn't always happen that way. Sometimes there are retirement riders and things like that. Why is it preferable to do it the way you're asking?
I think because if you're doing it now, the longer you wait to bring back the net salvage value, the more expensive it's going to be for customers at that time. So doing it earlier, you're spreading out that cost over a longer period. So
And I guess the
day
greater-
one impacts are less.
I'm sorry, I did not.
I'm sorry.
And I guess the greater the gap in that generation. If you waited and did it more in a rider than start now and get the net.
Right, there would be a larger cost at the end that the new customers would be paying for.
Okay.
Or the customers that were benefiting from the new generation would be paying for.
Okay. I don't want to ask you to be interpreting statutes like crazy, and this may be just a question that nobody can answer right now. But in 278, 264, 2D, it talks about, well, in the part just above that, talks about how a utility cannot commence retirement or decommissioning until, I can't read my own writing, replacement, the next word I can't read, but the new facility, the replacement generation, has been fully constructed, permitted, and in operation. And then in 2D, it talks about unless the utility can demonstrate it's necessary under the circumstances to commence retirement early. What would be a circumstance like that? A major breakdown?
Yeah, I think that's a fair potential, would be if while you're constructing your combined cycle, the unit shut down and you can't get it back on. I'm not sure at that point you would actually file for retirement or not. I'm not sure that's an actual apples to apples comparison. I think where you would potentially see it is, and it's right at the point that you're making the switch over, you could be where, due to transmission constraints, you're gonna have to retire the unit to get the combined cycle online. But I think that there's ways around that, and you would work with PJM to commission your combined cycle such that you can ramp down the coal plant and then bring the combined cycle online. So that's.
something
you can-
catastrophic
Yeah, I don't think it
would
would have to
trigger.
be anything catastrophic. Having said that, if we get to 2035, let's say, for instance, and we haven't filed a CPCN for a combined cycle, and something catastrophic were to happen and you had to shut down the unit, what would you do at that point? I mean, it's.
I kind of want to ask you that question.
So, first of all, you'd be heavily reliant on the market, and then you'd be coming quickly to file for a CPCN to get, I would imagine, file a CPCN to get the unit online. But you'd have to go through this whole process of the EPIC Commission and that whole process to actually get it done. I think the circumstances are pretty rare that it would be necessary to commence retirement before adding
Okay.
new generation.
So in your testimony, you talked about how we will eventually have to retire. Every generation plant that's currently in operation eventually will have to retire, coal or otherwise.
Yes, ma'am.
And that customers will pay for that.
Yes, ma'am.
And in your company's view, the terminal net salvage is the fairest way to ask customers to pay for that. Is that what I'm understanding from your testimony?
That's correct, yes. There's two pieces. There's the terminal net salvage value and then aligning depreciation with where we think the unit will eventually, when the unit will eventually retire. They're two separate issues, but they're both getting at the
Okay.
same.
So, as I understand it, there's a fairly clear plan about how East Bend is expected to, when and how we would convert and then eventually replace. And basically operate as long as it's legally possible and beneficial to customers to do so, but there's a plan. With Woodsdale, it seems quite a bit murkier to me. And I don't even know if this is an answerable question or if there's a different witness that could answer it, but how do we start talking about terminal net salvage of Woodsdale without a clearer plan?
So it is, again, as we've stated, it will retire at some point, and you're going to need to replace that generation. Under current statute, you have to replace it with dispatchable resources. So that limits, as we sit here today, limits your options for what you can replace Woodsdale with. And as a peaking unit, and particularly if you build a combined cycle at East Bend, you're not gonna need new baseload generation. At the most, highly unlikely that you would need new baseload generation at Woodsdale at that point. So now you're looking at peaking capacity, similar peaking capacity that you have at Woodsdale today. So something that you can turn on an instant and turn off. It's there for meeting peak demand, because you've already got a baseload generator operating, getting the energy you need throughout the day. So our expectation at this point, and again, because we're not planning out to 2042 at this point in the IRP.
And that is the difference in Woodsdale, is that it's beyond the 15 years
That's
of the
correct.
IRP planning period.
Yes, it should lay that foundation first, but yes, it's beyond the foundation, or beyond the planning period. However, knowing that what's required by statute today, knowing that our plan is to have baseload generation on already in Kentucky at that point, knowing that you're going to need to maintain reliability and adequate reserves per the statute, your most likely option is going to be a peaking unit, most likely a combustion turbine at that point in time. And so there is a high confidence that that is the replacement generation that we would be moving forward with. And it would certainly need to meet all those
Yeah.
requirements.
Just can't answer that yet, not really.
We can't answer the specific type today.
I apologize for these questions. I do. I thank you for your answers, and these are tough questions. I know it's difficult to do your job when there's constantly changing federal law or threat of changing federal law and state laws. And you also operate in North Carolina,
Yeah, North
where
Carolina.
there's a green energy mandate.
That's right.
Yeah, okay. And then Kentucky is sort of the opposite of that. Okay. I think that's all the questions I have for this witness. Commissioner Reagan, did you have another question? I'm sorry. Okay. Redirect.
Just a couple questions. Mr. Kalemba, do you recall questions from the chair about the rebuttable presumption and how the replacement generation and the retirement kind of work in tandem?
Yes.
Can you just, for the record, speak to the timeline for constructing a combined cycle?
Sure. So from the time that we file a CPCN to when it comes online, it's 8 years or so. Then when the EPIC Commission would add a couple of, 180, some time to that, 180 days or so, I think is the number. So we're talking about 8 years from when we say we want to move forward with adding a combined cycle at retirement till when it actually comes in service.
And Mr. Kalemba, sitting here today, do you know, would Duke Energy Kentucky build a combined cycle without knowing that East Bend is going to need to retire? Would we have 2 baseload generators operating?
No, we would not.
Can you explain why?
Well, first, cost, you wouldn't want to operate 2 baseload generators if you don't need to. But second, there's transmission constraints coming out of East Bend, and you can actually have 2 units operating at the same time and get, you could, in theory, have 2 units operating at the same time, but they wouldn't get the full capacity value because they'd be limited by transmission constraints at the site.
And from a resource planning perspective, does Duke Energy Kentucky try to match its generating portfolio to its customer demand with, some room to grow?
That's the whole purpose of doing an IRP, and what you're aiming to do is match demand with new generation. Because over time, demand's growing, generation's gonna retire, and you gotta fill that gap.
And understanding that, you are not an attorney, and I'm certainly not asking for a legal opinion, in your expertise from a resource planning perspective, do you see any limitations or constraints under the statute in your testimony, KRS 278-264, again, from a resource planning perspective, that would limit the company from filing to retire a unit as it's seeking to construct its replacement?
No, I mean, we would, absolutely not. I mean, we would identify and comply with all the requirements of the rebuttable presumption, which a 1-by-1 combined cycle does. So from my standpoint, we don't see any issue with being able to meet the rebuttable presumption with the plan that we've laid out.
Thank you. No further questions.
Sorry. So you said you don't see anything that would prevent you from filing to retire while you're building the other?
No, I'm sorry, no, we would make sure that we file and get approval to retire before we start building.
You don't think you already have to have the new facility built and in operation
We have
before
to-
you can file to retire? Because that's the way I read it.
No, respectfully, the way I read it is that you have to identify what that unit would be. Is it dispatchable by the utility or regional transmission? Does it maintain or improve reliability? Maintain a reserve margin capacity? Will that unit have the same higher capacity value and naked capability? Check. It hits all those. So our plan says that, yes, when that unit comes online, it's gonna hit all of those. Our plan also says, Part B, it's not gonna harm the utilities ratepayers by incurring net costs. So that our plan has to comply with that statute. So when we file our CPCN and we go to the Epic Commission and say, hey, we're complying with this part of the statute, we're complying with this part of the statute, we think you should approve our ability to retire and replace that generator in 8 years.
So the portion that talks about how cannot commence retirement or decommissioning until the replacement has been fully constructed, permitted, and in operation, doesn't apply here?
No, it applies, but that, to me, I read that as physical, right? So you can't physically start doing work to retire that
So
unit.
commencing retiring is commencing retirement.
Yes, I read that as commencing retirement is doing physical work to retire the unit.
Okay.
Shut it down, don't run it.
And maybe
We're
that
not
is the
gonna
way
do
we.
that until we have new generation online.
I'm talking over you.
I'm
I
talking
apologize. I
over
really
you.
don't want to. But so you don't think commencing retirement or decommissioning includes filing at the commission? You think
Oh,
that
no.
is just a physical action?
I read that as physical, absolutely.
Maybe that's the interpretation. We're gonna see.
May I ask one more question?
Absolutely.
Thank you. Mr. Kalemba, again, in your experience in, looking at statutes and interpreting them from a resource planning perspective, do you see anything in KRS 278-264 that would prevent the company from filing a request to retire a unit years into the future?
No, absolutely not. No, we can file, again, we're not physically retiring the unit, so there's nothing in here that I read that says we can't make that request.
Thank you.
Is that it for your redirect?
I'm done, thank you.
Ms. Gow?
No questions, thank you.
No questions, thank you.
And Ms. Grumman?
I think I have one question. In response to questions from your counsel just now, I heard you say that the purpose of the resource planning process and the proposal of new generation is to match generation to load plus a little bit of headroom, correct?
That's part of the outcome, right? So you're trying to get generation to match, at least cost, generation to match the requirements. And you can overbuild and add renewables, add more energy to give you less risk in the marketplace and things of that nature. But at the end of the day, you're not gonna, your plan has to meet the reserve margin requirements and the demand.
And I'm based on council's question, you may tell me, don't ask me about this, ask someone else. But how does that concept of wanting to build enough load to meet, or enough generation to meet load plus a little headroom, how does that intersect with the company's proposal to go from FRR to the capacity markets? And if you're not the right, I didn't understand how that would play in if you're bidding in and out of the
Right.
RPM.
So the way that I understand it, and I think Witness West can talk more about it, but we want to own and build generation in Kentucky for the benefit of our Kentucky customers. If a large load wants to connect, prior to when we can add generation to meet that load, we can use the RPM to go out there and purchase capacity on the market to meet that load until we can have generation on our system to meet that demand.
But you can't, and again, this may be Mr. Swez, but you can't pop in and out of the RPM and FRR constructs at will.
That's a better question for Mr. Swets.
And then to follow on to your question, you have a customer who comes on, they would exceed the available capacity currently available. Nothing would prohibit you from saying, we can have you online in using your timeline before in 8 years.
Nothing prohibits that,
Okay.
us from doing that. That's
And nothing would prohibit you from engaging in sort of bilateral contracts that that the customer seeking to interconnect sooner would fully pay the costs of.
there would be negotiations around what that is, but I don't think there's a
Okay, so
limitation.
before, when you were kind of mentioning this concept of matching generation to load, you mean that regardless of how the company participates with PJM, whether it's FRR or RPM?
That's correct.
Okay,
Yes.
thank you.
Staff?
No more questions, thank you.
Sure. And I don't have any others either. Any reason why this witness couldn't be excused? I would run if I were you. Just kidding, I'm kidding. Everyone's gonna be honest, but thank you, and you are excused.
Thank you.
All right, would we like to have a quick break now, or we wanna try to power through? Maybe it depends on, quick break? Okay, quick break. 15 minutes, I'll see everybody back at a little before 11. We are back on the record in case number 2024-354. And counsel, you ready to call your next witness?
Thank you, Your Honor. For our next witness, Duke Energy Kentucky calls William C. Luke.
Okay, Mr. Luke, raise your right hand to be sworn, please. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. Tell us your full name and business address.
William Luke, 1000 East Main Street, Plainfield, Indiana.
Counsel. You may ask.
Thank you, Your Honor. Mr. Luke, would you please state your position with the company for the record?
Vice President, Midwest Generation for Duke Energy.
And Mr. Luke, did you cause to file testimony and responses to data requests in this proceeding?
Yes, I did.
Do you have any changes or corrections to any of that information?
No, I do not.
And if you were asked those same questions today, would your responses be the same?
Yes, they would.
And is it your intent to have that information admitted into the record of this proceeding?
Yes.
Thank you, Mr. Luke. Your Honor, the witness is available for cross-examination.
Ms. Gall.
Yes, thank you, Chair. Good morning, Mr. Luke.
Good morning.
Is it accurate to state that the East Bend generating unit has performed well and has outperformed the North American Electric Reliability Corporation's average equivalent forced outage rate, or the EFOR?
Yes, it has.
And the East Bend has outperformed NERC's EFOR in 8 of the past 9 years, correct?
Yes, that's correct.
And the 1 year that East Bend did not outperform the NERC EFOR was in 2021, and according to your testimony, it was due to a generator issue that was resolved. Is that correct?
That's correct.
And you would agree that East Bend has provided and continues to provide considerable value to Duke Kentucky's customers, correct?
That's correct.
And based upon the information we just discussed, would it be fair to say that the East Bend is a valuable and efficient generating unit for Duke Kentucky's customers?
Yes, it has been used and certainly useful for customers.
As of today, Duke Kentucky has not set an official date to retire East Bend, correct?
That's correct.
And as of today, Duke Kentucky has not filed a request with the commission to obtain approval to retire East Bend, correct?
That's correct.
And as of today, Duke Kentucky has not filed a CPCN request with the commission to replace East Bend with a new generating unit, correct?
That's correct.
Thank you, Mr. Luke. I have no further questions.
Mr. Bay.
No questions, Your Honor, thank you.
No questions, Your Honor.
And staff.
Mr. Luke, I have a couple of questions on your direct testimony concerning the planned outage deferral request.
Yes.
You stated that Duke Kentucky is seeking to re-implement its previously authorized deferral for planned outage O&M expense, first approved by the commission in Duke's 2017 base rate case. But the commission denied both mechanisms in the 2022 case, citing that regulatory assets for scheduled and forced outages should be amortized over 5 years, consistent with the period over which they were created. And in this case, the current case, were those regulatory assets for forced and scheduled outages amortized over the period with which they were created?
I would have to defer that question to company witness Lawler.
Okay. And this may also be for Lawler, but I'm gonna ask anyway. In the last rate case, the commission held that forced and scheduled deferral mechanisms were no longer necessary, given that Duke expected the expenses to be in line with the base rate amounts. Does that still apply? Does Duke still expect
Yes.
these expenses to be in line?
Yes.
Okay. Okay, now, can you refer to your rebuttal testimony, page 4?
Okay, I'm there.
Okay, and could you just explain lines 3 through 7?
these lines speak to the cyclic nature of the maintenance activities that occur on a large coal asset. We plan and schedule around the major maintenance requirements on the key components, the turbine, generator, condenser, boiler feed pumps. So when you look at the maintenance requirements, those inspections and that maintenance is not necessarily performed every year. They could be on an annual, 2-year, 3-year, 5-year. It's dependent on operating hours of the unit as well. So therefore, that drives a cyclic approach to the amount of planned outage O&M that we may be executing any particular year. I think if you look at the history of our planned outage O&M, you'll see that it is cyclic, and then what we have planned, forecasted, is also cyclic in nature. So it's really around the maintenance requirements of the unit.
Thank you. I have no other questions.
Commissioner Reagan?
I don't have any questions.
And I don't have questions either.
Thank you.
Yeah. Any redirect?
Just, I think one. Mr. Luke, do you recall questions from council for staff about the maintenance expense, and you described it as being cyclic?
Yes.
Can you explain what that means in terms of dollars and budget for the company?
Can you repeat or rephrase
Sure.
the
Can you just
question?
explain
The
what you
dollar
mean
amount?
by cyclic? Like,
Understand, okay. Yeah, when I say cyclic in nature, I'm speaking to the budgeted dollars and what we plan to execute. When I mean cyclic, the dollar amount that's required to perform that maintenance in that particular year is going to be cyclic along with the required maintenance activities. So the maintenance activities are cyclic in nature, meaning that they follow I don't want to say a set frequency for that particular component, but that's basically what it is. You have each piece of equipment will require maintenance on a set interval. It could be typically hours-based, starts-based, so that in and by itself is going to drive that maintenance requirement, which drives this, I use the term cyclic, again, for maintenance, and then the dollars that follow that maintenance are required to perform that maintenance.
so does Duke Energy Kentucky spend the same amount for maintenance every year at East Bend?
No.
And can you explain how that factors into that cyclic nature that you just described?
Well, as we put the plan together based on the maintenance requirements, that's what's going to determine how much money we're spending in that particular year. As stated earlier, the unit has been reliable. We achieve that reliability by making sure that we are executing and performing the required maintenance on the unit, making sure we're doing what presents itself as the most value to our customers. So laying out that plan to drive reliability requires different funding from year to year in order to execute that work to maintain the reliability of the asset.
Thank you. And Mr. Luke, do you have oversight over other Duke Energy affiliated electric utilities that own generation?
I do.
And can you, which jurisdictions are those?
Duke Energy, Indiana.
And can you briefly explain whether there are any differences between how you manage the operations and maintenance for Duke Energy Kentucky versus what you may be able to do with Duke Energy Indiana?
Yes. The big difference would be the size of the jurisdiction and the number of units. So in Duke Energy Kentucky, we have one base load coal asset, that being East Bend, and we have 6 simple cycle combustion turbines at Woodsdale. So when we have to execute the required maintenance, as I mentioned, having only I should say, a limited number of assets in a Duke Energy Kentucky jurisdiction, it's different from Indiana, where I have a large number of assets where I can normalize my spend each year in Indiana because I have 7 coal units, and I have, dozens of simple cycle combustion turbines. So therefore, when I look at the maintenance cycle, I'm looking at it for the entire fleet. So I can normalize that across the entire jurisdiction. Also, if we have discovery work during planned outages, I have opportunities to prioritize across a larger jurisdiction with more assets to be able to, again, normalize that spend to where it's more consistent year over year. In a small jurisdiction like Duke Energy Kentucky, I don't have the ability to do that. I have single large baseload asset at East Bend, and I have the 6 units I mentioned at Woodsdale. So therefore, I cannot normalize the dollars associated with the required maintenance that we have to execute. Hence, going back to the term I used, cyclic in nature. Where I can normalize that in Indiana, I cannot normalize that in Kentucky.
Thank you, Mr. Luke. No further questions.
Is it that you can't normalize, or it's just more difficult?
It's certainly difficult, but I really can't because, again, there are certain inspections that are required on a certain maintenance interval. So if you were to look at, say, outage O&M spend perhaps last year versus this year in Kentucky, we're spending more dollars this year. Why? Because we did not have any major maintenance requirements that were due last year. They're due this year and next year. So it'd be like taking your car when you get to your 12,000 mile check or your 15 or your 30,000 mile check. You're taking it in on a certain maintenance interval. You're not bringing it in at, say, 8,000 miles for its 15,000 mile check. Again, if you drive a lot, that's going to change that interval as well. But again, it's set intervals that we're executing this maintenance activity. So I really can't here in Kentucky.
And as it relates to the 5 years that the commission recommended in the last case, how do those intervals compare? Are they longer generally than the 5 years, or they might happen twice during one 5-year period, or if you can say? If
Well,
there's a
I
way.
can try to help paint the picture. So for example, like a steam turbine major inspection, we execute those roughly, it's every 7 to 10 years. So at East Bend, we did an HPIP steam turbine major inspection in 2018. So based on a normal maintenance frequency for that unit, we would look to do that major inspection in the 2027, 2028, but we also do inspections as well, look at performance. So there's always some variability in when we actually execute that. That's a long duration. We have other maintenance activities that may be every 2 years or 3 years. So it really depends on where that 5-year period falls to know exactly what maintenance would be executed in that 5-year period.
So for the one you just talked about, that's every 7 to 10 years, the steam turbine inspection.
Correct.
I'm sure I said that wrong. If it was every 10 years, that'd be easy to normalize over 5 years. You do. I mean, 10 and 5 are divisible.
Correct.
But if it happened every 7 or 8 years, it's maybe a little harder
A
to
little bit
figure
more
out how that
difficult.
goes in the 5-year period. Okay, I understand what you're saying. Okay. Ms. Goode, recross.
No questions.
And for either of the interveners, do you have recross?
No, you're.
Staff? Recross? Oh, sorry. Okay. Any reason this witness couldn't be excused? All right, Mr. Luke, you're excused, so thank you.
Your Honor, before we move on, it has come to my attention that I may have forgotten to move to admit Walmart Exhibit 1 earlier.
Was it already in the record, though?
That's correct, and so I just didn't know exactly how you wanted to do it since we marked it.
Okay. Do we have objections?
No, Your Honor.
I just wanted to, Duke staff reminded me that I forgot to ask kindly, and I just wanted to not let the hearing go by and not raise it.
Let it be entered. Counsel, you may call your next witness.
Thank you, Your Honor. For our next witness, Duke Energy Kentucky calls James McClay.
Mr. McClay, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please have a seat. Tell us your full name and your business address.
Sure. James J. McClay III, I'm at 525 South Tryon Street, Charlotte, North Carolina, 28202, I believe.
Counsel?
Thank you, Your Honor. Mr. McClay, would you please state your position with the company, please?
Sure, I'm Managing Director of Natural Gas Trading.
And, Mr. McClay, did you cause to file direct testimony, rebuttal testimony, and responses to data requests in this proceeding?
Yes.
Do you have any changes or corrections to any of that information?
No.
And if you were asked those questions then today, would your responses be the same?
Yes.
And is it your intent to have this information admitted into the record?
Yes.
Thank you. Your Honor, the witness is available for cross.
Let's go.
Thank you, Chair. Mr. McClay, Duke Kentucky is proposing a comprehensive hedging program for forced outages and economic hedging, to which refunding of any gains and recovery of losses would pass through the company's FAC, correct?
Correct.
And Duke Kentucky did not prepare any economic study or any other study that compared outcomes with and without the proposed hedging program, is that correct?
That's correct.
Can you please refer to your rebuttal testimony at page 5, lines 16 through 21, and let me know when you're there, please.
Okay, I'm there.
Okay, can you please read that sentence into the record, or two sentences into the record, starting with the goal of a hedging program?
The goal of the hedging program was not to make a profit, but rather to mitigate customers' exposure to market price risk, smooth out purchase power costs, but the company's own generation units are not available, either due to outages or from economic perspective. The gains and losses from the hedges help to provide stability in customers' monthly bills.
Thank you. So according to this portion of your rebuttal testimony, the goal of a hedging program is not to achieve savings or make profits. Is that correct?
That's correct.
Is another goal of the hedging program not to incur a loss?
Not to incur a loss. No, I mean, you're mitigating volatility and, you know, that may fall how it falls. You may actually make money or you may lose money, but the objective is to mitigate the volatility and get a steady price for customers.
So just to make sure the record's clear, you agree that with the proposed hedging program, the company could make a profit or it could incur a loss, correct?
That's true.
And if Duke Kentucky enters into a hedge, it will most likely have a gain or loss when the hedge is settled, is that correct?
That's correct.
And if you enter into a hedge, or Duke Kentucky enters into a hedge, there's a cost for the hedge, and this cost is separate and apart from whether there's a gain or loss when the hedge is settled, is that correct?
Yeah, it's minor transaction costs. It's normal. And we don't have any extra people or anything like that. There's no costs like that. It's just that when you execute, sometimes there's a small cost.
When you say minor transaction costs or small costs, do you have an example of what that cost would be?
Like maybe $500 for a trade. And if we do it bilaterally, there is none.
Your Honor, if I could ask, Mr. McClay, could you please speak up a little bit?
Sure. If you do it bilaterally, there is no cost.
In your rebuttal testimony, you cite to gains and losses that Duke Kentucky has experienced from hedging in prior years. Is that correct?
Yeah, those were for scheduled outages. Yes, I did.
And one example you provided was a loss of close to $4 million in December of 2021. Do you recall that?
Yes,
It's page 5 of your rebuttal testimony where I
Yes.
just had you read from.
right next to the gain of $3,500,000, yeah, the same year.
In your rebuttal testimony that you just read into the record, you stated that another goal of the proposed hedging program is to mitigate price volatility and to provide stability in the customer's monthly bills. Is that correct?
That's right.
And if the commission were to approve of the company's proposed hedging program, and for example, Duke Kentucky had another $4 million loss, as it did in December of 2021, and that flows through the FAC rider, that would cause a spike in the customer's monthly bills. Is that correct?
That would, but the loss is really an opportunity cost. Although it's hard dollars here, but that just meant that, we hedged at a price, mitigated the risk, and that when it settled, it went in a different direction, not up, maybe down. Yeah.
And Duke Kentucky proposed a similar hedging program in the last electric rate case, case number 2022-372, correct?
Yes, we did.
And in case 2022-372, the commission denied Duke Kentucky's proposal to hedge force outages and economic purchases. Is that correct?
That's correct.
Duke Kentucky is also proposing to purchase capacity performance insurance and to recover that expense through the profit sharing mechanism or the PSM rider. Is that correct?
That's right, both the costs and the revenue.
And you did not address how much the capacity insurance would cost in either your direct or rebuttal testimonies, did you?
Yeah, that's because we've done some market engagement. We did receive a whole host of, we'll just call it, there's a lot of variability to the different policies because it's a standard insurance policy, and there's deductibles, there's premiums, there's amount of coverage. There's a lot of different factors in that. So, yeah, just to mention one, we do have some that we received, but yeah, I didn't mention any.
Can you please refer to Duke Kentucky's response to the Attorney General's first request for information, question 83E? And let me know when you're there, please.
E3E, okay.
Mr. McClay, you co-sponsored this response, correct?
Correct.
Can you please read this response into the record?
The company, in preparation for this filing, obtained quotes from 2 carriers for various policy payout limits and deductibles. As mentioned above, there are no standard CP insurance products, and each policy could be different and customized. Customized premiums quoted in the offers and the company received so far range between 1.7 million and 10.9 million for coverage of 17.6 million and 70.2 million. The company will compare different CP insurance offers and choose the policy that best fits Duke Energy Kentucky customers' needs and risk profile if approved to purchase CP insurance coverage.
Mr. McClay, would you agree that a range of 1.7 million to 10.9 million for the capacity performance insurance premiums is a large difference?
It's a large difference because the coverage is different.
And Duke Kentucky did not propose a specific or maximum premium cost to be approved for the capacity performance insurance in the pending case. Is that correct?
That's right. We're still in the process. That's only two quotes from 2 companies. There's more companies out there, so this is just preliminary indication of what we found.
The company has not performed any economic or other study that compare outcomes with and without capacity performance insurance, correct?
No, we have not.
Thank you, Mr. McClay. I have no further questions.
No questions, Your Honor. Thank you.
No questions, Your Honor.
Good morning, Mr. McClay.
Good morning.
Going back to the proposed new program for the hedging. Can you just confirm that Duke Kentucky has not conducted a long-term effectiveness study, on that new calculation for that hedging program?
Yes, because it's really not necessary. We've been doing this for 17 years for scheduled outages, and if you think about it, it's the same risk. If your plant trips, you're trying to mitigate actually the price and volatility for the customer, so you're doing the exact same thing, only for a shorter period of time. So in my mind, it's already been proven. We've done analysis back in, I think it was 2021, 2022, for our power supply program, that we did do some analysis, and we came to the conclusion that, you know, using the power markets is the most effective for the customers, and it actually provides good risk mitigation for, you know, price spikes, especially in the middle of, you know, a high demand period. Right now, we're subject to daily market volatility, and also when the market is actually cheaper than the cost of running the unit, we're not really able to lock in that price. So, you know, it's sort of something that's very standard in the market, and it's good optimization for the customers, and I think they'll benefit by it.
You proposed a new gas management program,
Yes.
wherein Duke requested the disposition of surplus gas through commodity sales.
That's good.
Does Duke have a standard in place that will trigger, if it decides to sell gas?
So managing power plants, especially Woodsdale, which is subject to variable dispatch by PJM, so they can dispatch it day ahead or in the middle of the day. So you purchase the gas for the units, and there are plenty of times where the units don't run their full schedule, at which time we do have an opportunity to sell gas into the market rather than leaving it on the pipe and parking it on the pipeline. Right now, we don't, and that's because we won't, basically you have to burn the gas to get recovery, but in, you know, good risk management of supply, gas supply, you should be able to sell gas that you're not using. And I'll add to that the pipeline right now has we have a parking agreement with them. And it's good because you wind up accumulating gas in the pipeline, because when you're not running the unit or you have leftover gas, it stays on the pipe. However, the pipeline will not be indefinitely tolerant of just leaving gas in the pipeline. I can tell you that we've run up some pretty large imbalances. And the only way to get it off the pipeline is to burn it at some later date. And chances are it's when the market is less expensive, where you could have sold it and probably mitigated your exposure. And, you know, now we're kind of stuck. We don't have many options. And it's normal gas management to be able to sell it. If we ever had a combined cycle, it would be mandatory to be able to do that. It's impossible to think about all the runs and the dispatches and the amount of gas that you're burning. It's inevitable that you don't get a perfect burn with the supply you bought. It's a mechanical, impossibility.
So you just mentioned you had an agreement regarding the unused gas. Has they ever given you notice that that Duke cannot use the pipeline to store the gas?
We have been told to work our balances down, which we've had to do. And it's nothing nothing formal. I mean, it's a phone call from gas control that says you have a lot of gas, you guys have to start working it down. And a lot of that is due to the pipe itself, because when they have operational restrictions, you can't use the gas to burn. So you have to keep buying gas and leaving it on the pipe. And that's why I'm saying to manage that gas, it's not every day, but you really need the ability to sell it, because that pipe's not going to indefinitely let you leave gas on there. If you think about what's going on in the U.S. with all the with the renewables, with data centers, you have all this additional demand coming online, and the pipelines are getting very restrictive and less flexible. So at some point, they may just decide, you know, we can't support this anymore. And we're trying to be proactive and get ahead of it.
And you may not be able to answer this one, but how many times have you had to, has gas been dispatched or burned off, since 2014?
Oh,
Or
yeah.
do it like in an average year.
Have been
maybe.
burned, and, well, so to give you an example, over the past 4 months, we've run up a balance of 450,000, which is enormous. And now we're down to probably about flat, because we've had to burn it off. It's just something that's, operationally, it's just not, in the customer's best interest to operate this way. Especially with Woodsdale has been getting a lot of dispatches, burning a lot of gas, which is all good. But the whole gas part of it it's starting to get, you know, it's difficult to match.
And my last question has to do with the capacity, performance insurance. Can you explain why customers should be, required to pay for Duke's non-performance, if it's their obligation to perform?
Well, you know, as witness Luke stated, that we actually have fantastic performance, but everything is mechanical, right? We do the best we can. These are machines that could have issues in the highest demand period of, you know, during PJM's operation, and if it coincides with a CP event, it could be very expensive, and the customers are getting the benefit right now of, you know, good operations, and, you know, if something should happen, they'll also get the benefit of the capacity revenue as well. So it's just, you know, and it's a 90-10 PSM is what we're looking at. So it's just, we still share, but it's in the best interest of the customers, once again, to protect against some sort of a catastrophic high dollar, you know, penalty, which could be upwards of $50 million.
Thank you, Ms. May. I have no other questions.
She asked all my questions.
Just a few for clarification. You said that there's a 90-10 PSM profit sharing mechanism for the insurance?
And cost sharing, yeah.
Yeah, for the
Well,
insurance? Or-
it would go through the PSM, so that's currently where we share.
The cost of the insurance?
Yes,
Would get
yes.
shared in that proportion, okay. A little earlier, you said that pipelines are getting more restrictive and less flexible,
Yes.
from my understanding. Why is that? Is it just increased demand?
So, yeah, they have higher usage. You have more gas plants. We're relying on the gas plants, like Woodsdale, to fill in the gaps. Anything that can't be served by the baseload units, so you have a lot of renewable penetration. Just a lot of fluctuations in load, and that alone, you know, if the pipelines, you're supposed to remain pretty close in balance to supply and demand, so you buy the gas you need. Sometimes there are situations where you'll take more gas off the pipeline. There's a little tolerance there that you can do that. It's called a park and loan agreement. And then sometimes you're gonna leave a little gas. And that's part of that same agreement. But, you know, there are these pipelines with the higher usage are starting to, what they issue what's called operational flow orders, OFOs. And those OFOs start putting you in a box and saying, if you go outside this tolerance, we're gonna hit you with a 3 times the highest cost of a certain index as a penalty per decatherm. So if gas, the highest cost gas for that day was $4, then you'll get hit with a $12 penalty for going outside of that tolerance. So they are, you know, all the pipes, if you think about in the US and what's going on with a lot of the coal retirements and renewables, there's just a lot of variability, especially in the real-time market when PJM is a large It has a large footprint, and there's a lot that goes on within PJM, and that could swing the demand pretty good. So, yeah.
Can you get multiple OFOs per day?
No, so the OFOs are usually, what they can do is they issue an OFO, and they'll, for example, this past January, I think it was 30 days in a row. They left us with one day where they didn't do it. They'll have an OFO, let's just say, do not overburn, right? In other words, don't take gas from the pipe for your plants, otherwise you'll get a penalty over a certain tolerance. And usually it's, if you think about it, it's about 2,000 decatherms, right? One of those plants in an hour burns that. So you have to be so close in tolerance and manage it so closely. And a lot of times, some pipes will put it on both sides, so you can't take gas or leave gas above a certain tolerance. They haven't done that yet. They've usually picked one side, but a lot of the pipes in the, Transco is one of them, and in the east, there's a lot of the pipes that are a little older, less flexible, might do that, so. And we're just trying to get ahead of what we see coming, with the higher utilization. And the good news at Woodsdale is it does have fuel oil backup, which has helped us a lot, where occasionally if we've had to burn more, we can put on oil, and save, if it's economic, and save the penalty, but that's not, we really need the flexibility to manage our gas position. And it's not every day, it's just occasionally that's what happens. And we had days in the high demand periods where we bought the gas and we were forced to leave it on the plant, on the pipeline, because we couldn't sell it. 3 days later, prices dropped from $6 to $2.50, and now we're burning $6 gas in a $2.50 market because we couldn't sell it. And that's hurting the customer.
In response to a question from the Attorney General's office, Ms. Goad, she was asking you about a similar hedging program that was proposed in the last case that was denied. Is this one similar or identical? And if not, if it's just similar, what's
Yeah.
different?
So we use we asked for the same thing, exact same. We're using the exact same products that we use to hedge for the scheduled outages. Everything is the same customers, same market, same product. You're buying power, financial power. It's all the same. And 3 years later, if you think about the volatility that we're having in the gas market, in the power market, having that ability to be able to lock in a price, especially we have some. If we lose a plant for a certain amount of time, we internally know, this is going to take a week to fix, or 2 weeks. So it would be good to be able to lock in the price in the market, especially if we see warm weather coming, or if it's in the middle of warm weather, because then you're not subjecting yourself to those price spikes and higher costs in the spot market, because that's, if your plant goes down, you're buying in the PJM spot market.
So have outside factors changed in those 3 years? The volatility is increased?
I would say the volatility is worse. You have, we talk about the pipelines, we talk about the renewable penetration, we talk about more gas, coal retirements. It's very volatile. Now, I'm not saying every day, a day like today, it's probably perfect outside, and it's probably not much volatility, but there are plenty of days during the summer and winter where you get the volatility.
We don't get to know what it's like outside today. All right, that's all the questions I have. Redirect.
Just a couple of questions, Your Honor, thank you. Mr. McClay, do you recall questions from counsel for staff about operational flow? There was a question about volatility, and you had responded about operational flow orders and having to, during those periods, you can't burn gas, you have to keep buying it. Do you recall that?
Yes.
Can you just explain that a little bit, please?
Sure. So when you get a dispatch, you buy supply for your dispatch for a certain amount of hours that the plants are going to run. And and during the operational flow order, if there's a do not be short, let's say in the pipeline, in other words, you have to buy the gas you need and probably a little extra, just in case in case you overrun, because PJM can keep you online for an extra hour, 2 hours, 3 hours, and you may not have the opportunity to buy that gas. So at the end of a gas day at 10 o'clock, that whatever is left over sits as an operational imbalance on the pipeline. The next day, if you get a dispatch, whatever is left over, you're not allowed to burn. So you have to go out and buy for the next dispatch and for the next dispatch. And if you buy gas and you don't burn at all, then all the gas sits there for the next time. So it's a continuous cycle until they lift the OFO, and then you can start to burn it down. And then you have to work with gas control, because obviously you can't burn it all down at once and take it off the pipe. They want you to gradually burn it down as you get dispatched. And there's no guarantees that you will be dispatched within the next 2 months. I mean, it just sits there. So that's what, I hope that explains it a little bit more.
And during those OFO periods where you're having to buy gas each day and you're not allowed to burn whatever might have been the remainder from the prior day, are those periods, do you know when gas tends to be more expensive?
Yes, during the high demand periods, you do get price spikes and gas is more expensive. That's right. We do know.
And so when those OFOs are eventually lifted and that higher price gas is what we're able to burn, that gas, do you know if that's generally or typically higher than what we could otherwise replace?
That's right. The average, so what happens is when the high demand is over, gas prices come down, and you can't buy those gas prices. You have to burn the higher prices off the pipe. And if you had the opportunity, you could have sold in that higher price market, reduced your imbalance, and create value for the customer and buy at the cheaper price.
Thank you. Do you recall questions from staff, council for staff about the capacity performance?
Yes.
And you had mentioned that customers have received a benefit from the performance of East Bend. Are you familiar with that situation? Can you explain it?
Yeah, so during capacity performance events at PJM, if you perform better than your unit is, for their capacity that they're expected, or generation that they're expected to produce, you get a bonus. And I know we received a bonus. Witness Suez probably knows the numbers, but we did receive bonuses from overperformance, yes.
And do you know whether customers received the benefit of that bonus?
Yes, they did.
And do you know how they received it, through what mechanism?
It was a PSM.
Okay, thank you. No further questions.
Reed Cross, Ms. Cowd.
No questions, thank you.
Jermaine.
No questions, thank you.
Ms. Grumman.
No questions.
Staff.
No questions.
Any reason this witness couldn't be excused? Mr. McClay, you're excused. Thank you.
Thank you.
Quarter till 12. Mr. Suez is next?
Yes.
I think maybe he's a long one, or longish.
I don't have any questions.
No? All right, let's give it a shot.
All right.
Welcome back.
Thank you.
Would you raise your right hand to be sworn, please? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please have a seat and tell us your full name and your business address.
My name is John Suez. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
Counsel.
Thank you, Your Honor. Mr. Suez, would you please state your position with the company for the record?
Yes, I'm Managing Director of Trading and Dispatch.
And did you cause to file testimony, including rebuttal and direct, as well as responses to data requests in this proceeding?
I did.
And are you adopting the data request responses of any other witnesses?
I am.
And can you explain what that is?
I'm adopting the responses to two data responses of Kim Hughes.
Thank you. Do you have any changes or corrections to any of that information?
I have two changes.
Would you please walk us through that?
On page 41 of my direct testimony on line 10, between the words day ahead and reserves, I omitted the word scheduling. So it should say day ahead, scheduling, reserves. The second change is on my attachment to my direct testimony, attachment JDS 4. The title says current recovery, that should say proposed recovery. That's it.
That's it, thank you. So with those corrections, if you were asked the same questions today, would your responses then be the same?
Yes.
And is it your intent and desire that all of that information be admitted into the record of this proceeding?
Yes, it is.
Thank you. Your Honor, the witness is available for
Office
cross-examination.
of Attorney General.
No questions.
Okay, Mr. Beck.
No questions.
Ms. Graham.
Yeah, just briefly. Good morning, Mr. Suarez.
Good morning.
You testify here, and I understand the commission has issued an order on the company's request to move from FRR to RPM, correct?
That's correct.
I want to focus on, you make a statement at page 15 of your testimony about the zonal separation in the DEOK zone. I'll give you a chance to get there.
I'm there.
In your capacity, in your role with the company, do you monitor what happens at PJM beyond just the DEOK zone?
Yes.
So are you aware that in the last several years that Dominion Energy was FRR and recently returned to the RPM?
Yes.
And are you aware that in their current fuel factor case that they have requested to recover approximately $1.92 billion in purchase capacity costs from PJM?
I was not aware of that.
And are you aware that, like the DEOK zone, the Dominion zone also separated and cleared at prices that were higher than the rest of PJM?
So I'm aware, sort of related, it's in my testimony, or maybe not this case, it could be the FR case, but they call it the PJM minimum internal reserve requirement, how much you're required to keep capacity in your zone. So ours is currently 4%. I'm aware that Dominion's went to 100%. And basically they had, my understanding, I don't work for Dominion of course, but they had no choice but to move to the RPM because they could not literally meet their FR plan.
Right. I'm not saying that you're exactly the same. What I'm just trying to focus on is the concept that, although not for the exact same reasons and at the same level, the DEOK and the DOM zone were both, they cleared at prices that were somewhat different from the average price through the rest of PJM.
I think 3 of the past 7 years now, the DEOK zone has cleared at a higher price.
And that's because in the general geographic area of the DEOK zone, there's not as much available resources as one might otherwise need.
Yeah, it's not just resources, of course, it's resources plus the ability to bring in energy from other areas, so transmission as well. So it's
you're
both
having-
combined.
I apologize, I didn't mean to interrupt you.
That's fine.
But you're having to pay more to bring it in to the extent you even can bring it in unless it's constrained from capacity transmission constraints.
So we're talking about if you're in the RPM, we're talking about the capacity market, so we're in the RPM, so the load would buy at a higher price, but because we own generation in that zone, we would sell that generation at a higher price as well. So it goes on, we're a buyer and a seller at the same time.
Are there any other utilities in the DEOK zone?
Duke Energy Ohio, of course. Besides Duke, Ohio, I'm not sure if City of Hamilton's considered a utility, I don't know.
So if you're clearing prices in PJM are higher, but you're also selling higher, the sort of theory is that those net each other out.
Yes, and in fact, we did the analysis for the other FR-RPM case, and we showed because there's obviously many scenarios. There's low price scenarios, there's high price scenarios, there's you're long, you're short. But in 3 of the 4 scenarios, the best financial result for customers, i.e. it lowered their bill, was that a move to RPM benefited them. And if you think about a high price scenario, it benefits them. When you're long, it benefits you because you have more generation to sell, so you receive more money than you pay for the load. So that's basically like what I said, you're a buyer and a seller at the same time. And if you have more generation capacity than your load buys, you sell, assuming your generation is in the same area as your load, you're selling more, and you're still buying, but you're buying a lesser amount because your generation's higher than your load.
Okay, I wanna think about this for a second. The concept of doing better for customers under the RPM construct depends upon the availability of the company's generation resources to offset costs.
Well, so maybe I'm not answering your questions, but
Well, no, this is somewhat of a different question. I'm just, you indicated that in 3 of the 4 scenarios, RPM was the better outcome for customers versus FRR. And what I'm saying is that embedded in that outcome, in those 3 out of 4 outcomes, is the necessity of the company's generating assets to operate as a hedge and offset costs.
the necessity is the generation assets are located inside the zone, and we own our own assets, and we are using those assets for our customers to serve that load in the resource plan. So yeah, it's based on a number of assumptions, but biggest assumption is probably that we own generation at the same time we're serving load.
But it's the latter point, right? If it's not merely owning the generation, it has to be available to serve load. If you went into an outage situation unexpectedly, and that generation was unable to operate as the hedge, then that would affect how valuable participating in the capacity markets would be.
Well, so you kind of switched over to energy there for a minute. So if a unit's unavailable in the energy market, clearly it can't provide.
You're right, I did switch, I apologize, but if it's unavailable, if it's offline.
Okay, so in the case where East Bend is not, when I say unavailable or offline, what I mean, it doesn't have any capacity value. So if we just, now at that point, if we have less capacity, we're now in a short position, so we have more load, less capacity. Under the FR, we have the risk of not fulfilling that FR plan, and that was one of the reasons that in the 3 of the 4 boxes, it's better for customers to be in RPM, and that's where you're short. At high prices, you run the risk of basically failing to serve your FR plan, and there's some pretty big penalties to not fulfill your FR plan in PJM.
But the alternative in the RPM is that you have to go out and procure alternative capacity, correct?
So you don't have to. Certainly, so it is, I think we're talking about if the generator were to go away, it's the same thing if a load comes on, right? Ultimately, at that situation, you're short. You have more load than gen, right?
Okay.
Be it your load goes away or you add load, it's the same result, right? So if more, I like to tend to think of it as more load comes in the system, now what do? Right? Under FR, this is where the risk of being an FR is for us. We're still in FR currently to this day. The risk is you don't satisfy your FR plan. In RPM, you could do one of 2 things. You could look for a bilateral transaction. You could contact counterparties and try to purchase capacity on a longer term basis while you have that new power plant built. That's one option. The other option is to buy more while that power plant's being built, is to buy more capacity from the RPM. So you have 2 options.
But you offered both of those options in the context of new load coming online, or I'm sorry, new load, new customers
did.
coming to the system.
Yep.
But whether it would have been the FRR construct or the RPM, you're not obligated to immediately serve a customer if you don't have the resources available to serve them, correct?
I don't know that. That's kind of more illegal, I think. I mean, there's obviously, there's what occurs when a new customer wants to enter your system. Obviously, there's a transmission requirement, right? You have to have the distribution transmission. That's not my, purview, it's not my area of expertise. There's a legal question, like, do we legally have to serve a customer if they come on and wanna be, they wanna build a load in our service territory? I think that's a legal question. I don't know the answer to that question. I can't really answer from the transmission distribution or the legal side, I really don't know.
Well, I understood you to be saying that there's a risk in the FRR context of Duke Energy Duke Energy Kentucky receiving a penalty because new load comes online and you had insufficient resources to meet your FRR obligation. Am I summarizing what you said?
That's correct.
Okay, would you view it as reasonable for the company to interconnect new load if it knew it was going to place it in a position of receiving a penalty from PJM?
I don't know if we have the choice to turn down new load. You can turn down new load, I'm sure, if you physically don't have the transmission distribution to serve that load. Obviously, if the wires can't support that new load, clearly, I would think that's reasonable, they can't be built. I can see that. I don't know if we have the right to say, no, I don't want this new load. First of all, we don't want to be, I don't think we want to be put in that situation as a company, right? I don't want to be the one that hampers the economic development, right, in the northern Kentucky area. But let's say that new load comes in, I don't know if we have the right to say, I don't think we do. If you come in, I'm gonna get a penalty from PJM, so I don't want you to come in. I don't think we have that. I don't think I have that ability.
Do you think you have the ability to say, hey, we can't connect you in 2025, but we could connect you in 2028?
And that's kind of an economic development question for those folks, but I'm sure there's some give and take. I don't know, but I'm sure there's some
Okay.
give and take you could have with the new customer, sure.
Okay, so it's fair to say that you don't know whether the utility has available to it the right to delay interconnecting a new customer.
Yeah, more of like, we work with economic development folks, but that's not really stuff that I would get involved with directly.
Okay, and so it's fair to say that when it comes to the impact of new load coming to the system, you don't know what happens on the back end. Your focus is more on the various options at PJM when it comes to participating either as an FRR or an RPM in the capacity.
That's correct. And
Okay.
there's a witness, Ibrar is our load forecasting witness. He might have more information on that, and I'm not sure if there's an economic development person in
That's
this
okay.
case or not, but
No, that's okay. I don't have any other questions.
What was the name of the witness you just said?
Ibrar, and I don't know how to pronounce his
Like
last name,
Khern.
Khern.
Yeah, he's like
Oh.
it's witness
Kira.
13. Kira.
Yeah, Kier.
I didn't
just always
recognize
say-
that name, but it was.
I just say
first name.
Ibrar.
Okay. Gotcha. Okay, is that it, Ms. Grumman?
That is, thank you.
Staff?
Yeah, do you have, it's Schedule L 2.2, it was the kind of red line tariffs that Duke had filed in this case, particularly with respect to the fuel adjustment clause tariffs and the PSM?
I do not.
Okay. I'll just refer to them then. So I'm looking at the red line version of the fuel adjustment cost tariff. Did you ever review those in preparation for this case?
It did not.
Okay. Are you familiar with the changes to the PGM billing line items that are included in the?
I am. I sponsored many of those changes, yes.
Okay. So I'm looking, and this is Schedule L 2.2, page 75.
Yeah, I don't have that, so I'm just kind of going to my
Yes.
part of my testament that has a lot of the BLIs.
Yeah, I'm just gonna kind of identify some of the changes. So the language of I'm looking at Part E, it says, kind of listing the items that are included in the cost of fuel. The native portion of fuel-related costs charged to the company by PJM includes those costs identified in the following billing line items as may be amended from time to time by PJM. And then it goes on to list like a number of billing line items. Are you kind of familiar with that paragraph?
I'm not, but I'm pretty familiar with FAC and I'm in the PSA.
So I guess I just want to ask, the billing line items, there were some that were removed and then some that were added, and I just kind of wanted to get into the reasoning. I'm assuming the initial definition is not changing, So you've got, E is supposed to be the native portion of the fuel-related costs charged to the company by PJM, and then it says, including those in these billing line items. And so, one that's being added is 1216. Do you know, is that a new billing line item for PJM, or is it an existing one?
I gotta look and see, do I talk about it in my direct testimony? There's a lot of different BLIs. I thought I did.
Page 41.
There you go, page 41, thank you. So, this, you wanna know, explain what it is, kind of that?
What it is, and it's, my main question is just initially what it is, just to set it up, if you could explain, but then also, did something change that now has native portion of fuel costs in it
So,
that required it to be added here?
so the pseudo-tie balancing congestion refund, that's what we're talking about, right, 1216. So, we don't currently today have a pseudo-tie, right? So a pseudo-tie, and this gets, like, what is a pseudo-tie? Because we tend to use that a lot. I think it doesn't really, well, let me explain it real fast, the best I can. So a pseudo-tie is a way to electrically move a power, I say move with air quotes, and I shouldn't be using quotes, but it's a way to move a power plant from one area to another. So let's say that Duke Energy Kentucky were to acquire a new asset, and that asset was in a different RTO, or it was in a different balancing authority. You would pseudo-tie that unit. You have to acquire firm transmission, then you would pseudo-tie that unit. So through the EMS systems of the energy management systems of both, wherever the two groups that are controlling the grid, they basically have to shake hands. So we would move that power plant from one area to another. So it's a way you could acquire another resource in a different area and move it electrically. Again, I want to use air quotes, you move it into the Duke Energy Kentucky area. And because you do that, you would then be subject to, and it could be a charge, or I believe it could be a charge or a credit. It's called refund. And the reason why I'm familiar with this is because we actually do this for Duke Energy Indiana. Our Madison station is pseudo-tied into MISO. And so there's gonna be a plus or minus. You gotta pay the difference between the LMP at one location and another location. And so there is no pseudo-tie today. Both Kentucky's unit stations are inside a DEOK.
So I guess the question would be, would there be specific fuel cost line items within that billing item if you're pseudo-tying it in?
There would be, because it's the congestion refund. And so, just like in the FAC for the native portion in the FAC, there is 1200, 1210, actually 1210 and 1215. So let's see, I'm sorry, basically it's the congestion and the loss factors. So it's 1210, 1215, 1220, 1225. Those are the congestion and loss. So those are considered fuel. And this one would be, for the native portion, it would be fuel. It would look like the same charge or credit.
So, and I had some other questions about this later on, but I guess I'll wait on that.
I want to just make sure I'm
Yeah.
correct. I did refer to my attachment 4, and I'm looking at 1216 under attachment 4, and it has the X under FAC and the X under PSM. So I want to make sure I said it correctly.
So,
Your Honor, may I approach? We have a copy of
Yes,
the
yeah.
tariff that
Yes.
council is referring to.
Thank you, sir.
when it says native, the native portion, does that to you, I mean, to me, that would mean Duke Kentucky's actual generation, correct?
I think it means that, so if East Bend were producing at 600 megawatts, and the Duke Kentucky load, the amount of customer demand was 500 megawatts, the native portion of East Bend is the 500 megawatts. And we had 100 megawatts of a non-native sale, right? So that's what I would call the non-native portion. To me, the native portion means that first 500 megawatts in my example.
Okay, but it would be generation that is actually owned by Duke Kentucky.
In the current, yeah, because we only assets Kentucky owns are the ones we own at East Bend and Woodsdale, and then, you know, any of the behind-the-meter assets. For 1216, this is a pseudo-tie, that would be a charge if we acquired a generator and we pseudo-tied it.
I guess my question is why add that billing line item now and not when you actually acquire a unit to which it would apply?
Well, let me make sure it only applies if it's your unit, not somebody else's unit. I think that's the case. So I do believe this is your pseudo-tie. So I think you're right. I think you'd have to own the unit in order to get this. You'd have to own or contract. I guess you wouldn't have to own if you signed a PPA, but you'd have to be the one, either owner or the recipient of the power through a PPA agreement in order to get that charger or credit.
But if you, just looking at the fuel adjustment cost though, I mean, it lists the billing line items, but the billing line items are also limited by the first sentence because it says the native portion of the fuel-related costs charged to the company by PJM includes those costs identified in the following billing line items as may be amended from time to time. And just to point out, I can point it out specifically to you, but some of these billing line items appear both in the fuel adjustment clause and in the PSM rider, which I'm presuming you're not recovering the same cost twice, both in the fuel adjustment and the PSM rider, correct?
That's correct. So again, that back to my example, like East Bend was at 600 megawatts and Kentucky's load was 500 megawatts. If you got a charge or a credit, you would allocate a certain portion of it to that. So if you got a charge of $1,000, then, you know, you would have some of that go to FAC, some of that go to PSM. The sum of those together would be $1,000. So they're not additive. You're allocating a portion of that to wherever that generator went, the native and non-native portion.
So I guess I was a little confused. The billing line items, when you're getting this from PJM, you're getting a bill and it just has a billing line item, and then does it just have an amount for that billing line item?
That's correct.
It's not broken down in any more detail?
It is not.
And then, because it was in multiple, some of these billing line items are in multiple spots. My assumption was that perhaps there was further breakdown within those billing line items, but you're saying that's not the case.
Not from PJM. So, and I don't do this process, but I work pretty closely with the person that does. And so, the person who does this actually has to take those charges and allocate, because his name's Scott Burnside, but he allocates the energy from that generator to either native or non-native, and then there's a secondary process that allocates the billing line item, so he has to do a further breakdown of the information that came from PJM.
And how are you all determining how to allocate those billing items? Is it purely based on energy? Is it, like, how do you determine, like, what portion of East Bend in a particular month is going to be allocated to Kentucky residents as the native portion versus the non-native portion?
So he actually does an hourly stack. And I want to say it's hourly. I don't think it's anything sub-hourly, but I'm just going to say hourly. So each hour, he looks at the generation and the load, and he allocates, and there's, you know, of course, more than just East Bend. It could be East Bend, plus Woodsdale, plus another Woodsdale. And there's a procedure, and there's certain rules, like if a unit is performing a test, like it's allocated in a certain way. But he follows this procedure, and generally speaking, he starts from lowest cost, so the lowest cost resource gets allocated to native load, and then as the resources get more expensive, then eventually, if there's more generation than load, the more expensive resources get allocated to non-native load.
And
And I realize there's some confusion there, so I say non-native load, it's a PJM sale. So the more expensive resources get allocated to serving that sale in PJM. It's just extra generation that we didn't need to serve our customers. Instead, and kind of an accounting standpoint, it was used to serve a non-native sale.
but when, as an FR entity, when you're selling the energy, you're selling all your energy into PJM and buying it all back, correct? But you're allocating the lowest cost to Kentucky customers, is that what you're saying?
So whether we're FRR or RPM, that doesn't really matter, really, from
Energy.
Yeah, we're talking energy, but yeah, from a, that doesn't change, that's a good question, though, it doesn't change the stacking process. So regardless how we participate in the capacity market, in an energy market, this person I mentioned is doing the stack every hour, generation, lowest cost to highest cost. So basically, he calculates, how do we serve the load, and by what units serve the load.
But what I was saying is though, you're selling it all into the market and then buying it all back, but when he's doing that stacking, the cheapest portion, when you're doing the allocation, he's allocating that to Kentucky customers, and then the non-native is then,
Yep.
the more expensive is allocated to non-native.
And again, another good question, because we always say we sell all our generation to PJM and we buy all of our load from PJM. And that's true. The mechanics in the market, that's exactly what we do, right? We offer the generation, we buy the load. But from an accounting standpoint, after the fact, it looks like the lowest cost generation was just used to serve that load. So it both happens, right? Yes, all of it gets sold to PJM and all the load gets bought from PJM. But then after the fact, we basically match up that lowest cost generator to serve that first megawatt of load, and we start incrementing higher and higher. So from an after the fact allocation standpoint, it looks like the lowest cost unit just went to serve the load.
And is this process contained in the cost allocation manual, or is that policy that you're talking about, is that located somewhere else?
I'm not sure if it's like a policy or more like a business, set of business rules. I'd have to.
Do you know if it's written down anywhere to where we could request to get a copy of how that allocation is done?
I believe it's written, but I don't do that. I don't do that job, and there's no witnesses here that actually do that.
Okay.
But I do believe it's written down.
I'll just send a post hearing data request and you all can respond, explaining, either producing it or explaining the issue with it. Just to kind of go through the rest of these here on this, the 2366, kind of just give a brief explanation and, why it's being included now and wasn't included before.
Where are you in the record, Ben?
I'm on, it's Schedule L 2.2, it's Volume 12, PDF page 62 of Volume 12 of the application. Or PDF page 462.
Thank you.
You said 2366, right?
Yes, sir.
So this goes actually a lot of the ancillary services markets, ones changed. So PJM, before this change, they didn't always have separate day ahead and real time. So starting at the beginning, ancillary services, right, those are the services necessary to to basically ensure the reliability of the grid, right? Regulation, the ability to move a generator up and down, so adjust its output second to second, right? There are other ancillary services called synchronized reserves. So that's, forget the one we talked about here, we're talking about 2366, and that is day ahead synchronized reserve. Okay, so synchronized reserve, those are generators that are synchronized to the grid, so they're literally part of the big machine, right? So they're basically connected to the grid, but they're held back, so to speak, but there's generation that's that's not being generated, that's held back in case the grid has an emergency and we have to raise that output of that unit up. That's what synchronized reserves are. So we've always had them, our PJM's always had them, it's pretty standard, all utilities have them, but PJM didn't have a separate day-ahead and real-time component. So they only had a real-time component, and they've created the day-ahead synchronized reserve because they basically wanted to adjust their ancillary services market, so they had a day-ahead component and a real-time component of each. And so in this example, 2366, day-ahead scheduling reserve was the new charge.
Okay, so that's a new charge that you all believe fits within the definition of fuel costs.
So it's new, but it's also, it's not new because we used to have a balancing synchronized reserve. So we've always had that, and in the last, I think in 2017, we went through all this and we said, okay, we agree synchronized reserve is at least the native portion is fuel. Right, so it has I'm just checking my JDS attachment 4. So it has the X next to FAC and the X next to PSM. So the native portion is considered fuel. So in 2017, we said balancing synchronized reserve is fuel, and so we got to allocate it between the fuel portion in native load and the non-native portion that goes to the PSM. And then PJM came along and took that and said we need to have both a day ahead and a real time. It's the same thing, but they've now expanded it to both the day ahead market and the real time market. And sorry it's such a long explanation, but
No, it's fine. I mean, I appreciate it. I guess I'm just a little confused as to how that would be fuel.
so in order to produce those reserves, you have to actually increase generation on the unit. So basically you have to actually, the generator just sits there, and then once it actually, they have an event, and a generator comes offline somewhere else, then we raise the output of our unit up consuming fuel.
Would there be any other costs associated with that? But you said the negative is fuel, but then the positive you don't consider to be fuel?
The positive, no,
Well, I thought you said the negative is fuel and then the positive is in PSM, I thought you said.
so
Or
the
did I reverse
non-native
that?
portion, because in that JDS 4, there's an X where that says FAC, and an X that says PSM. So again, we go back to that allocation where we figure out what unit supplied to reserve. Was that unit going to serve native load, or was that a non-native cell? And most of the
Okay, I'm
time,
sorry.
these are native load, yeah.
You said native. I thought you said negative. I'm sorry.
Oh, I'm sorry. Oh, if I probably mumbled.
Sorry. I guess same thing, 1980.
So 1980 miscellaneous bilateral, just for my JDS 4, it does have it for all, it does FAC, PSM, and base rates. And let me just refer to what I said about 1980 if you don't mind.
Sure.
I'm not sure I talked about 1980 unless somebody else can find it.
Do you know what that account is offhand?
Miscellaneous bilateral. So a bilateral transaction is just a transaction that occurs outside the market. So it can be facilitated by PJM, but it's a transaction that occurs between two counterparties.
And is that billed through PJM?
So what typically happens is counterparties they may agree to where we want it to be billed by PGM. You could do one of two ways. You could not bill it through PGM, or you could bill it through PGM. Most counterparties, we don't have any in Kentucky. Like in Indiana, we have a fair number of bilateral transactions that occur through the market. So the counterparties agree. They basically, instead of me sending you a bill, then basically you're already transacting with PGM. I'm already transacting with PGM. Let's just let PGM take the money from me and give it to you, or vice versa. I think that's what it is, but I don't see where I've really mentioned it. And that's my best understanding of 1980.
Are you the best witness to talk about how these different accounts are allocated? I know you said that the person that does that's not here. Are you, I guess, the second best option of the people that are here?
So in terms of the person who's doing the allocation, I can probably speak that better than anybody, but once that allocation occurs, Witness Steinkuhl is definitely better and understands how all this flows through customer costs.
Okay, the FAC, because I did have a question. If you look kind of on the page before that we were looking at on the tariff, and the fuel costs are defined, and this is effectively directly from the regulation, but the actual identifiable fossil fuel and nuclear costs associated with energy purchase for reasons other than identified in paragraph C of this subsection, but excluding the cost of fuel related to purchases to substitute for forced outages. Is there a way to, with what you all deem to be fuel-related costs identified in these various billing line items, is there a way to determine what portions of those are attributable to forced outages? Or is that tracked?
So this is an interesting question. I don't think there's anything attributable to forced outages, because if the unit is forced offline, generally it's not gonna have activity, right? So if a unit is forced off, it's the absence of that activity, right? So East Bend typically receives a credit in or a charge, but mostly a credit in like 1220, I mentioned it earlier, like 1200, 1210, 1220. So if East Bend were to be forced offline, it just goes to zero and it has no revenue coming in. So, but to answer your question, Witness Steinkuhl is definitely better in terms of like this tariff and understanding how things flow through the FAC. But I definitely can talk about the forced, like what we do around forced outages. But, it's in my testimony, but ultimately your question was, if a unit is forced offline, which BLIs relate to that? And I think there wouldn't be any, because units that it's forced offline, that generator doesn't have any more transactions, so it's the absence.
And I understand that generator doesn't, that's language from the reg itself, and frankly, some of that was probably written before RTOs were contemplated. But, with you all selling everything into and buying everything from PJM, I assume you would dispatch both East Bend and Woodsdale on an economic basis. You bid in at what you think is the marginal cost of operating the unit, is that correct?
Yes, we definitely, so we offer the units, and then there's a little bit of nuance to that, but yeah, we offer the units generally at their marginal cost. And we run the units when they're in the money, right, when they're economic to operate, right? So just because we lost East Bend wouldn't really impact how much we're gonna run Woodsdale. Right? If it's economic to run Woodsdale, Woodsdale runs independent of East Bend's operation.
I guess the question would be though, if, say, East Bend is in the money and there's a forced outage, that would mean that the actual cost of energy in the market is higher than the marginal cost of operating East Bend. So you are losing East Bend, which is, as you said, hedging the cost of energy to Kentucky customers. So there would then be a marginal cost to Kentucky customers based on the higher cost of energy in the market that's completely unhedged. Is that correct?
Unhedged unless we go back to Witness McClay and we talk about that hedging, Currently, if East Bend is forced offline, then we are basically reliant upon the PJM market to determine the price that ultimately we're paying for purchase power. But as my direct testimony talks about, then we're only able to recover in FAC the cost of the cost of that purchase power. And so when you lose East Bend, it might be purchase power from PJM that you're buying, but it also could be additional allocation of Woodsdale, which was more expensive than East Bend. But nonetheless, let's just say we lost East Bend, now we're buying from PJM, so we're only allowed, my understanding is we're only allowed to recover in our FAC the cost of what East Bend would have cost to operate. So if East Bend was a $30 unit and the purchase power is now $40, you're not allowed to recover that the more expensive, the $10 megawatt hour additional cost.
That's what I thought. That's what I was getting at. That extra, you're hedging with East Bend, but everything is going through these billing line items. You're both selling and purchasing.
Mhm.
How do you determine what portion, is attributable to that forced outage of East Bend, where you no longer have that hedge available?
So first we have to determine, when was East Bend forced off or derated, so forced derate and forced offline. So I go through and I determine from hour-ending 3 on this date through hour-ending 12 basically we look at the plant generation and we determine when it was forced off, all right? So now we know the time period it was forced off. I report that information to this person I mentioned earlier, Scott Burns, at his group. He then does a calculation of how much of that generator forced outage, how much of that is replacement energy able to go through the FAC, at least I believe he's the one that does this, and how much of that is not able to go through the FAC. And Witness Steinkel definitely, that's where kind of I stop and Witness Steinkel takes over.
So you think there is some, at first I thought you said there was no effort to determine that amount, but you think that there is. And then you think Witness Steinkel would have an explanation of that?
There definitely is an effort. We do it hourly, so every hour, again, it goes back to the stacking I talked about. It's really sort of the same process. Every hour, what was the load? How much purchase power did we have? What was the generation from each generator? Stacked from the lowest cost to highest cost. And then you have that additional portion is, well, was this unit unavailable due to a forced outage or forced derate? And that's kind of where I end, and then that information then flows to, I think Witness Steinkel can answer the questions, what she does with that information.
Okay, back to just the billing line items, and I apologize, I know this is taking time, these are a lot of different things, we just want to know what's being added in here. So I'm on 2980, I think, if you could give kind of a brief explanation of what that is and why it's being added at this point, if it's a new thing, or that there was some change in circumstances that you think it now should be added.
So you said 2980?
Yes.
I think that's basically the same thing as 1980, so everything I talked about, the bilateral, that's the credit, right? So the 1980 would be the charge, the 2980 is the credit. It's really no different than the explanation we talked about for 1980. It's the same thing. They go together.
1999.
So 1999 is PJM's customer payment default amount. It could be for various reasons, right? So we don't know, depending on who in PJM defaults and for what reason they default. So this is what was used by PJM during the FTR. The company was called, we all remember the company's name was called Green Hat. We've talked about this before, but it could be, but it doesn't have to be for something like this. That was related to FTRs, so financial transmission rights. But it could be for any other reason that a customer defaults. That's where PJM would collect what was left. It could be for a lot of different reasons. Could be fuel related. Could be, it really could be non-fuel related. That's why we have all three of the boxes there, because it's really case specific.
So you mentioned the Green Hat. Are you familiar with the case, apologize to jump around, but since you mentioned Green Hat, I just wanted to jump to this. Are you familiar with Commission Case 2020-31, in which Green Hat was addressed by the Kentucky Commission?
I remember I'm not sure if that was our case or someone else's case, but I remember we had a case where it was addressed by the commission.
Okay. And do you remember what the commission determined with respect to the cost associated with Green Hat?
I don't believe we were allowed to recover the costs.
And that's the same type of cost that would be in billing line item 1999.
Well, it could be for anything, really. So like Green Hat was, like I said, FTR related, but a customer in PJM can default for many reasons, right? It could be, it might not be, it could be the capacity market, could be, just energy market. So that particular reason was tied to FTR, but the other reasons that a future customer could default, we just don't know.
And you say a customer default, what does that mean? Like a wholesale customer defaults and you all have to eat the money?
Basically, and maybe not a wholesale customer, but like an entity in PJM effectively can't pay their bill.
And that's distributed to everybody? Or how does that work?
I don't know what means PJM. I'm sure they have credit requirements, and I don't know that. But ultimately, once they exercise all of that, if there's a shortfall, I believe that's where the shortfall will be collected.
And why is it Duke's position that those costs should be recovered as fuel costs from Kentucky customers?
Well, it depends on the specific, if it's a purchase power, right? So if it's purchase power, that is fuel. But if it's capacity, that's non-fuel. So it, again, depends on what the specific default is related to.
Is your proposal in this case that specific? So that we can understand the difference of being what's proposed, and if there's a different witness, obviously, we should ask them.
I think it would have to be specific case by case, because we don't know what, I don't believe I said anything, and witness Steinkel is that's probably getting into witness Steinkel's area. It's a good question.
Billing line item 1999, it appears in the fuel adjustment for native, I think it appears in the PSM rider for non-native. How it appears in all these various sections, would there be any portion of anything billed through 199 that wouldn't flow through to Kentucky customers?
It would not flow through?
Yeah.
Well,
Where it's included in all of these different mechanisms you have and the allocation that you all do to divide it among those native, non-native, and maybe there's something else, but is there any portion of it when you're doing that allocation that wouldn't flow to Kentucky customers?
So under my JDS4, I have 3 boxes checked, and then FSC, PSM, and base rate. So I would add base rates in there. But to answer your question, no, I believe it would be one of those 3.
So all of line item 1999 that is charged to Duke Kentucky would flow to customers under the proposal.
Well, part of it in the PSM would not flow to customers because that's shared, right?
Okay. Other than the part that would go through the sharing.
I think that's correct. Again, Ms. Steinkel could answer that better than I.
Has there been any material changes since the commission's decision denying the recovery of the Green Hat default to how PGM bills or credits billing line item 1999 that would make it appropriate to change the treatment in this case?
I don't believe anything's changed with PGM, but to my knowledge, they've only used that, at least from a larger standpoint, one time. But I think the recovery is requested. There could be situations where it could be fuel related, so I think it's really specific depending on the situation.
Just going back to the billing line items, kind of going down to the PSM rider. And forgive me if I double up on these from above, I'll try not to do that. So, I think we talked about 1216.
Okay.
Talked about 2366. And I'm assuming the answer would be the same. And I'm looking, I apologize, I'm looking at the OSS net proceeds from off-system power sales. It includes non-native portion of fuel-related costs charged to the company by PJM, including but not limited to those costs identified in the following billing line items.
Did you say OSS?
Yes, it's the next, it's page 76 of Schedule L 2.2.
Okay, so it's in the tariff.
Yeah, it's a page or so
Okay.
after that FAC that we were looking at.
Okay,
And if you look at the red line, it kind of has the similar billing line items that are changed there.
yep.
I guess I'm a little confused. The net proceeds from off-system sales would seem to be earnings or revenue, but these are then billing line items.
Well, so the ones, obviously, there can be charges or credits, right? So even the ones that start with 1,000 can be a credit in some situation, and the ones that start with 2,000 could be a charge. So again, the unit that gets, and that stacking, the units that were allocated towards non-native sales, the BLIs associated with that activity would then flow through the PSM.
Okay. So the costs that we talked about that would flow through those items, whether they're costs or a credit, I guess, would, if they're allocated in non-native, they go through here, and they're the exact same costs, or I guess credits that we talked about above.
I wasn't sure what you meant by here, but in this tariff,
In this definition of OSS, the net proceeds from the off-system power sales.
yeah, this is probably getting into like witness Steinco.
Okay,
Can't
okay.
really, I'm not really much on the tariff, sorry.
You're fine. I know you said you're not much on the tariff, and I'm gonna get to a question about PJM, so you can defer some of these to witness Steinco, but I think some of them will be for you. If you look here, I'm looking at, this definition of OSS. It says net proceeds from off-system sales includes the non-native portion of fuel-related costs charged to the company by PJM, including but not limited to the costs identified in the following billing line items, as may be amended from time to time by PJM. The included but not limited to would potentially be read as, being able to add things, without amending the tariff. And I guess my question for you is that really necessary? Could you just say, if we say the commission wanted to include all these billing line items in that definition, would you just say the non-native amounts in this billing line item? And what I was getting at is when PJM changes their billing line items, or the company determines that they need to add one because of a change in circumstance, what would prevent the company from just changing the tariff at that point to add that billing line item and explaining to the commission why they're doing so?
Yeah, it's probably a better question for Ms. Steinco.
I guess the one question I had for you related to that, though, is if PGM is changing their billing line items, I'm assuming that would be a somewhat involved process that they would not do overnight. Would that be correct?
That's correct.
Okay.
There's the stakeholder process, they have meetings and educational sessions to explain what they're doing, yes.
So there would be lead time to make changes or propose changes to a tariff if
Yes.
PGM was changing?
I believe so, yes.
And I just want to check to see if we talked about all these really quick. I'm going down onto the next page, and there's some additional billing line items that are listed here. I think 1246. You could maybe just give some explanation of why that's being added and what it is.
1246 is load response test reduction. And likewise, I guess we'll do 2246 at the same time, that's the credit. Okay. So my direct testimony, it states PJM added it in June of 2023, these new BLIs, 1246 and 2246. These are for entities that test load management programs. So if you have a load management program where you reduce load and there's an expense to that, then you would have both a revenue and a charge from that expense.
And how would that come up, I guess? Why would Duke be charged if another entity is doing that?
Well, because we're benefiting by the load management, right? I mean, it's benefiting the entire market. So I believe there'd be I'm not sure how much would be directly impacting Duke.
Is this something, what is the load management, I guess?
So demand, basically demand side response, right? So reducing load, and so resources can either produce more generation or you can reduce load. So that cost to reduce load is what we're talking about here when it's being tested.
This would not be reducing load within, would this be reducing the load within PJ or Duke's service territory?
So a customer that signed up for that, let's say a customer, basically participates in a load management program, has signed up for a program that allows us to use that demand side response to satisfy, like currently today, we use part of our demand side response to satisfy our FRR plan. So it's not a huge amount, but I think it's less than 5 megawatts, but we use that, it's called a resource, right? So a reduction in load is basically the same as adding generation. So we use that resource to help satisfy our FRR plan. And in that, if there's a requirement to do a test, and not every load is gonna have a test every year, at least my understanding is if a load just participates and is already tested because they're participating in the market, they might not be tested. So we might not have a test. But if your load didn't get called by PJM, then you might potentially have a test.
So would this only be for people with, or customers within Duke's service territory? I guess I'm a little unclear how. I understand that you as a load serving entity would use that to reduce your load, and then you would, credit Kentucky retail customers who are participating in that and potentially penalize them, if their failure to follow through, resulted in you all exceeding or additional cost to PJM. But if other entities within PJM, are doing this, I'm assuming they're outside of a vertically integrated utility.
Well, there could be in a vertically integrated utility as well, right? Just because they're, not in Kentucky, right? There's more entities in PJM that are still vertically integrated. But nonetheless, I mean, I'm not clear on is if you perform a test, a load management test, and it costs, we spent money to perform that test, we would expect compensation from PJM, right? So we would receive that credit back from PJM, whatever the cost was. Maybe the cost was 0, but let's say there was a cost, we would receive that credit back in that 2246. Now, what I don't know is under 1246, where you have a charge, whether you're paying for other entities' tests as well. I think that's the way this would work, but I don't know for sure.
Okay. I guess 1361 and 2361, since they're mirror.
So 1361 is secondary reserves and 2361, secondary reserves. So, I can talk about that one better. So, it's again, it's an issue where PGM restated their ancillary services market. So they used to have something called day-ahead scheduling reserves, and they changed that to secondary reserves. But both are the types of reserves where you have up to 30 minutes to bring a generator online. So they've expanded that, where they previously only had day-ahead scheduling reserves, they've renamed it secondary reserves, and now they've created a real-time and a day-ahead. So we have a balancing secondary reserves and a day-ahead secondary reserves. I'll start with the day-ahead market, and a balancing secondary reserve, the real-time market. It's the same reserves we had in the past. They've just expanded it to day-ahead and real-time.
And does that have to do with capacity?
Now, this is all energy. So this is basically having enough energy sitting back like a coiled spring, ready to go if they have a situation where they need to deploy that energy to serve, to basically.
So is this
make
like spinning reserves? Is that what it is?
This is actually, it's sort of the same thing, except spinning reserves by its name implies that the resource is spinning.
Yeah.
Whereas secondary reserves can be, the only requirement is they have to be online within 30 minutes. So they're not necessarily spinning, but it's sort of the same thing.
So if it's not online, are you paying like for the marginal cost of keeping it ready to come online within 30 minutes, or?
So let's see.
I guess I'm just wondering, how it fits here into this.
So 1361 and 2361, we have checked for just the PSM boxes checked. So, and this is, the assumption is that resource is not online, not consuming fuel, but that the cost and the revenue associated with 1361 and 2361 would be allocated in PSM because it's not fuel related.
Okay. Getting to the end here, that 2367.
So 2367 is exactly the same thing. That's the real-time, I'm sorry, the day-ahead portion. 2361 was the real-time secondary reserves. 2367 is the day-ahead secondary reserves. Same product, just in the day-ahead market instead of the real-time market. Same thing, it's only checked, 2367 is only checked under PSM, so the cost of that doesn't consume fuel.
Okay. 1471.
So exactly the same thing. The 1400 charges are the reconciliation, so basically meter data changed, but it's really exactly the same as the underlying charge.
And this is a new billing line item within?
It is because they renamed scheduling reserves secondary reserves, yes. I'm sorry, they renamed scheduling reserves secondary reserves. I'm not sure, I might have said that backwards.
I guess going down to 1390 and then the 2390.
Yes. So fuel cost, the fuel cost policy, not sure what it's called, fuel cost policy, it is called penalty. And it's so we have, it's non-fuel, so that's why the FAC is not checked, right? So just PSM's checked. So we have to follow, we have to make offers to PGM that are both cost-based offers and then your price-based offer. And when you make a cost-based offer, PGM will use that offer if you are, you fail basically the free pivotal supplier test. Basically, you have market power. So PGM has very strict rules for how you create that offer. And we do a really good job of, we have to create a policy, so you have to create this multi-page policy that says how you're gonna calculate your cost. And then you gotta follow it exactly. And you make these offers every day. And if you fail, you receive a charge. But at the same time, if others fail, you receive a credit. And so we've always received more credits than charges. In fact, we've only had one charge for $500 the entire time, but we've received many thousands of dollars of credits.
Okay.
All through the PSM though, or it would go through the PSM.
And the credit would come through 2390 and then the other would come through 1390?
That's correct.
And I guess I was a little confused how those charges and credits, it's, if you fail to perform at when you're required to at the cost, or just if you fail to deliver energy when you're supposed to after you bid in, and the market's at that cost, is that what it is?
This is a little different. So it's actually a cost associated with just simply a paper exercise of what did you submit. It has nothing to do with whether you actually did anything in the market, whether you ran a generator. I typed in a number to PJM and I said, the cost to run East Bend is $31. It's more complicated than that, but it's $31. And PJM said, no, it's not. It's 30. You're over. You get a penalty. So they actually tell you the cost. It's all paper. But if you know exactly the policy, you should be able to avoid the penalties. But when PJM receives payments from others, we get that payment. That's what goes into the credit. We've received like $32,000 of refunds. I think we've had $500 in costs.
I'm just what is the benefit to PJM of that process?
It's a lot, but ultimately the benefit is because they want to ensure that a generator that has the potential to market power is probably the wrong word, but they call it fails. If you have an electric area where you have a generator that has, for lack of a better word, market power, then that generator needs to make sure they offer at a price where they can't take advantage of that existence, so that electrical configuration.
Okay, so
It's to
kind
protect-
of to prevent market manipulation.
It's to protect customers.
Okay.
Yeah.
And I think we talked about the other, is there any other items in here that would be considered penalties or performance penalties? Either additions or down in the cap. There's some additions down in the cap down there.
And so I'm gonna ignore the ones from the FR case that we've mentioned earlier, but those aren't, we're not really talking about these here, right? And they were already decided upon, the commission already decided anyway.
If they're in here, just maybe point them out for the record in this case, actually.
Mr. Bellamy, are we close to?
We probably do have like 30 more minutes. I don't know if you want to take a break.
Well,
and-
when you feel like you're at a good stopping point, I think
Okay.
maybe we'll.
I think maybe we're approaching that.
Let me know.
Okay, thanks.
You ask about penalties, right?
Yes.
Additional penalties.
We're essentially anything where they would charge you something for not performing as you're supposed to.
So I think 1669 would be in that category. Obviously capacity, I mean, it depends on what you view as not performing, right? 1667 is capacity performance. That's not something that's new to this case, but it is something where you didn't perform or you got a bonus because you overperformed, but it is related to performance.
Okay.
So 1667, 1669. Related to performance or a penalty?
The 2669, I guess, would be,
Oh, yeah, I didn't mention the credits,
so those would be credits where
Yep.
you're getting where other people are penalized?
Yep.
Okay.
So I always tend to focus on the 1000 series, but yep. So I said 1667, so conversely 2667, 1669, that's a new penalty, 2669, the new credit penalty. The ones from the RPM case that were denied that were considered penalties would be 1663, 1666, and 2663 and 2666.
Is that how, actually, keep looking, and once you're done, it's okay.
You're looking for ones related to penalty or performance.
Either or,
Right,
I guess.
right.
You can kind of explain it.
I think that's, after my scan, that's all I can find, but, anyway.
That's fine. Just one last question, then I'll let us break. With all the, what you would consider penalties, there looks like there's a charge and a credit for each.
Mhm.
Is it always such that if other people are penalized, PGM spreads that to the other members, and if for every penalty, there's a corresponding credit to other members that other people, when they're paying the penalty, is that kind of how it operates?
Pretty much. I mean, it may not be perfect because there could be like 2 BLIs on the credit side that go to 1 BLI on the charge side, because there's some, but for the most part, I mean, PGM is, I call it revenue neutral, like minus their administrative costs and their cost to run the market. Pretty much, they receive a penalty payment from somebody, then it goes back out to the rest of the market participants based on it depends on, call it pro rata share, but yeah, it depends what kind of penalty it is. Sometimes it goes to certain entities only. Sometimes it goes to everybody.
Okay. Thank you.
You're welcome.
I did have some more questions, but I think I'm at a breaking point if you would like to.
Okay. Look, I think since we've made some good progress there, that we'll try to go ahead and do a whole hour for lunch. If we start getting tighter on time, we may not do that the next couple of days, but let's still take an hour, and I'll see everybody back, right at 2. Good afternoon, everyone. We are back on the record in case number 2024-00354. And let's see, we were in the middle of staff cross. And I'd remind you, sir, that Mr. Swez, that you're still under oath. Please proceed, counsel.
Just a few more questions, actually. Are you familiar with the final order in case number 2024-285, the request to move to an RPM entity?
I am.
And that, generally speaking, authorized Duke to move from an FFR entity to an RPM participant and authorize certain changes to the right of PSM related to that. Is that your understanding?
Yes.
Do you have any knowledge of, and I know this is probably in the record in the other case, but when would you all expect that kind of transition to be complete? And really the reason I'm asking is, when would you expect to file the rider that was approved in that case to kind of substitute for the one that you're asking for in this case?
So obviously, we just received the order, so we're still reviewing it and everything. But we are, we can't apply, so the upcoming auction in July is for 26-27. So it's too late to apply for 26-27. So the next auction is the 27-28 delivery year, and the deadline for that is October. So we can, between now and October, tell PJM that we're gonna move to RPM, as long as we do it by approximately October 1st. So the effective date would be June 1st, 2027. Would be the first time we would be in PJM as an RPM entity.
Okay. And we were just trying to get a kind of a handle on what the I guess the rider would look like now, or the PSM rider would look like now versus what you had requested approval for with the changes in that order. And as a post-hearing data request, I didn't know if you could provide essentially a red line, a version of what you proposed in this case, redlined against what it would look like after you move to an RPM entity, so we could see what you expect the changes to be at that point.
I think that's possible.
Okay. And obviously, if there's an issue, you all can respond, and explain that. I just wanted to ask were you here, there was a question about the negative reserve margin. Does Duke Kentucky currently have a negative reserve margin in PJM?
So I think I did hear, I was listening on the video stream when Mr. Colombo was asked about the forecast pool requirement, FPR.
Yes.
I know that's a weird thing, and it is negative. So before PJM made the switch to the ELCC methodology, you basically took your load and you multiplied by a reserve margin, a positive reserve margin, so you increased your load. But once they switched to the ELCC, it kind of, all the math kind of got weird is the way I think about it. And so now, as you recognize, the load actually goes down because it's like 0.94 or, whatever it was, so roughly 0.94. So including the reserve margin, the load actually drops a little bit. But that's because at the same time they did that change, they made the change to the ELCC methodology for generation. So the generation changed as well. So they made all these changes at once. And the best way I can think about it is the fact that our load doesn't peak at the exact same time that PJM's load or time of greatest need occurs. So they're occurring at different times.
Okay.
I think that's my version, but it is one of the most confusing things. So that's my understanding.
Okay, so they're applying sort of like that ELCC analysis to the load also, is that?
it's just the resources and the load, all of it obviously goes together, because ultimately, like Mr. Kalemba talked about, resource planning and the purpose to serve the load and the capacity, the resource adequacy markets and PGM, the purpose is to make sure that we have adequate resources to serve the load. So, yeah, they changed all that at the same time with the goal of to make sure they had reliable, resource commitment resource adequacy available for the market to serve the load.
And do any entities have negative or positive reserve margins, or does everyone have a negative?
I don't know. It's a good question. I just know ours. I don't know of others. I'm not sure if it's public or not.
Okay. Does Duke currently ever sell capacity into the PJM market? Or I guess as an FR entity, you're not a member of the capacity market, but can you sell like in bilateral transactions capacity?
Yes, I believe we could. We are long, so I believe we could make bilateral transactions outside of the market.
Okay.
But to my knowledge, we've never done that. We have made a couple purchases, but I don't recall any sales. Let me think for a second. Technically, it's a sale, but so if you go back long enough, Duke acquired the 31% ownership of East Bend from Dayton Power and Light, and they had made a sale from the unit into the PJM market that we received once we bought their share of the unit. That's probably not, it's not really a bilateral sale, so I would probably say no.
And this might be a question for someone else, but in the current PSM rider, is there any component that would reflect the sale of capacity to other parties where customers would get credited for that?
That's a good question for Ms. Witness Steinkohl. I'm not sure.
Thank you so much. I don't have any other questions. Thank you.
You're welcome.
Thanks. I think my questions are from Ms. Stengel.
Okay. My question is from what seems like a long time ago, just sort of back to when we were talking about the difference between Dominion and Duke. That was a while ago, right?
Yep.
So is the difference in outcome as far as Dominion getting a penalty for not being able to meet their FRR requirements and all those sorts of things, is the difference that Dominion doesn't own generation? I'm not familiar with Dominion.
I believe they own generation just like us.
What's the difference
The
then?
difference, well, so ultimately both companies decided, ultimately, we're still reviewing the FR to RPM case, but decided to pursue moving to RPM. The biggest difference was that PJM minimum internal reserve requirement. So this is something that PJM does once a year. They tell you, they say, this is how much of your capacity must come from inside your local delivery, your local balancing area, your local delivery area, I guess.
Is that DEOK?
That's DEOK, exactly. And so right now, ours is pretty low, it's 4%, but it's been as high as 30-ish%. And so, but it's, the problem with it is it's a stroke of the pen. PJM, now granted, it's through an analysis, right? But the amount of energy that you can import changes as a function of transmission lines, but also as a function of how much load is inside of your zone. So things change, generators retire, like other generators that we don't own potentially could retire, load could come in, transmission changes, and then that internal reserve requirement goes to 100%. My understanding with Dominion, their requirement went to 100%.
Okay.
And that's where I think, again, they were gonna get a big penalty unless they moved to RPM. They just couldn't keep up with the load.
Okay. And so you've been moved to RPM for what, 5 days now?
Yeah, well, officially, we have to tell PJM between now and October 1st. Yeah,
Okay, so not exactly. even
not
yet.
exactly, right. And that would take effect June 1st of 2027.
And I think that's the only question I had marked. redirect.
Yes, Your Honor, thank you. Just a few questions. Mr. Suez, do you recall questions about how the company does its after-the-fact allocation between native and non-native of PJM costs?
I do.
Do you know whether the commission has previously examined the company's after-the-fact allocations and how that whole process works in prior cases?
Yes, I do. I'm also a FAC witness, and I believe in one of the FAC cases, a few years back, I don't know exactly the year, but we did have a lot of data responses and in-depth questions related to the allocation of native and non-native energy.
And how long has Duke Energy Kentucky been performing that after-the-fact allocation?
So for PJM, it'd be since we joined PJM, which was 2012.
Okay, thank you. Do you recall questions from counsel for staff about going through the list of PJM BLIs related to generation performance and potential penalties?
I do.
Do you know whether this commission has previously authorized the commission to include recovery of any of those BLIs through its profit-sharing mechanism, rider PSM?
Yes. I'll double check the BLI number real fast. So BLIs 1667 and 2667, non-performance and bonus performance for basically we call capacity performance, has previously been authorized to flow through PSM.
And have any costs or credits flowed through those riders to date?
Yes, during Winter Storm Elliott, the company was a net provider. We received credits, more credits than charges. About $900,000 net was flowed to the PSM.
And was that a credit to customers?
I'm sorry, it was a credit. So it was a net credit to customers flowed to the PSM for those two BLIs.
Thank you. And do you recall the circumstances around when that was approved? In terms of when the commission approved that, in what case it was, and why?
Sorry, I'm thinking.
If you don't know, it's fine.
I've forgotten, I'm
Okay,
sorry.
that's fair. Do you recall questions, Mr. Suez, about, from commission, counsel for commission staff about whether Duke Energy Kentucky has engaged in any bilateral sales of capacity?
I do.
Has Duke Energy Kentucky, has it been able to engage in any sales of capacity in PJM's incremental auctions?
Yes, we have participated in the incremental auctions, both buys and sales.
Can you explain a little bit of the circumstances around that briefly as an FRR entity, how we've been able to do that?
Sure, so in the BRA, the initial auction, you're required to hold back 3%. So roughly, for us, roughly 30 megawatts. And then when you get to the last auction, right before the delivery year, called the third incremental auction, in addition to other updates, so there's updates to like the ELCC and how much your capacity is worth. But one of the things that occurs in the third auction is they allow you to now sell your capacity that you held back from the BRA. So in the third auction, that's one of the benefits is that at that point in time, an FR entity is finally allowed to sell. So that'd be an example of where we actually sold in the incremental auction. And likewise, we could buy in the incremental auction as well if, like, for instance, our load changes, or load forecast changes, if our generation, the amount of capacity from a generator, if that drops due to a change in the ELCC methodology, that would drop, we might have to buy back.
Thank you. And to the extent Duke Energy Kentucky has been able to sell any capacity into the markets, is that limited to just the length of capacity that's not in our FRR plan?
It would be the amount of capacity that wasn't needed to satisfy our FRR plan. It was basically essentially extra.
Okay, thank you. No more questions, Your Honor.
Okay, recross by Attorney General.
No questions.
Mr. Bain?
No questions, thank you.
Am I saying that correctly? Your last name, am I pronouncing that correctly? Yes.
Grunman? Oh, Bang.
Yeah, Bain.
Bain.
Wait, I think she's talking to you.
Miss Grundman.
I was like, I don't think she said my name yet, no cross.
No cross. Any recross would stay.
I just had just a couple questions. The allocation, I was just wondering how you get the bills from PJM. Is it just for Duke, Kentucky, or is it for the Duke zone completely?
It very nicely, because otherwise it would be really complicated, only Duke, Kentucky.
Okay, thank you.
Yep.
Yes, that's it.
And I don't have anything else either. Any reason why this witness couldn't be excused? Okay. Thank you, Mr. Spencer.
Thank you.
And Mr. Cynthia, if you want to call your next witness.
Thank you, Your Honor. For our next witness, we call Rebecca Hawk.
Ms. Beck, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please have a seat. Tell us your full name and business address.
My name is Rebecca Buck, and my business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
Thank you, Your Honor. Good afternoon, Ms. Bach. Could you please state your position with the company for the record?
Yes, I am the Director of Allocations and Reporting.
Thank you. And did you cause to file testimony and responses to data requests in this proceeding?
Yes,
Do you have any changes or corrections to any of those documents?
I do not.
And if you were asked those same questions today, would your responses then be the same?
Yes,
And is it your intent that this information that you sponsor be admitted into the record of this case?
yes.
Thank you. Your Honor, the witness is available for cross-examination.
Thank you, Ms. Goode.
No questions.
Mr. Bain.
No questions, thank you.
Ms. Grumman.
No questions.
Staff.
We don't have any questions.
Commissioner
I
White.
don't have any.
Nor do I. Any reason why this witness couldn't be excused? Thank you, Ms. Beck, for coming. You're excused. And when you're ready, call your next witness, please.
Thank you, Your Honor. For our next witness, Duke Energy Kentucky calls Sharif Mitchell.
Good afternoon, Mr. Mitchell. Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
Yes.
Thank you. Please be seated and tell us your full name and business address.
My name is Sharif Mitchell. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
Thank you. Good afternoon, Mr. Mitchell. Would you please state your position with the company for the record?
Accounting manager 2.
And Mr. Mitchell, did you cause to file testimony and responses to data requests in this case?
I did.
Do you have any changes or corrections to any of those documents?
I do not.
And if you were asked those questions then today, would your responses be the same?
They will.
And is it your intent that this information be admitted into the record of the case?
Yes.
Thank you. Your Honor, the witness is available for cross.
Thank you. Ms. Gunn.
No questions.
Mr. Bain.
No questions.
Ms. Grumman.
No questions.
Staff.
No question.
No.
And I don't have questions either. You must have done a good job with your testimony. Any reason
I'll take
Mr.
it.
Mitchell can't be excused today? Thank you, sir. You're excused.
Thank you.
Your Honor, if we could have just a couple minutes to swap attorneys and for our next witness.
Do we want a 15 or we're just changing seats?
Just a minute or two to swap out. Thank you. We're on a roll.
Good afternoon, Commissioners.
Good afternoon. Are you ready?
We're ready.
All right.
The company calls Mr. John Arpanizza.
Mr. Panizzo, if you would raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please tell us your full name and your business address.
John R. Panizza. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
You may ask counsel.
Thank you, Your Honor. Good afternoon, Mr. Panizza. Would you please state your position with the company?
I am the Director of Tax Operations.
And did you cause direct and rebuttal testimony to be filed in this proceeding along with discovery responses?
Yes, I did.
And do you have any corrections to the testimony or data request responses in this proceeding?
No, I don't.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
And is it your intention that those documents be admitted into the record today?
Yes, I do.
Thank you. And with that, Mr. Panizza is available for cross-examination.
Thank you. Attorney General's office?
Thank you, Chair. I do have some questions. Mr. Panizza, I would like to discuss Duke Kentucky's property taxes. Can you please refer to Duke Kentucky's response to the Attorney General's first request for information, question number 117, and let me know when you're there, please.
I am there.
And Mr. Panizza, you were the respondent to this question, correct?
That's correct.
Can you please turn to attachment 1, page 1 of this response?
I am there.
This is the property tax expense calculation work paper that you supplied in response to this discovery question, correct?
That's correct.
And in this attachment, you are taking the actual 2023 property tax expense, escalating it on various factors to determine a property tax expense for the calendar years 2024, 2025, and 2026, correct?
Yes, with one exception. When you say expense, realize that that is the bills of the property taxes for 2023. Sometimes the expense varies because of how we accrue it, right? Meaning it could come in one year, but we could make adjustments in a different year.
Thank you for that clarification. You then computed a test year property tax expense amount of $16,415,344 based on 6 months of the 2025 amount and 6 months of the 2026 amount. Is that correct?
That is correct.
And can you read your full sentence at the bottom of the attachment 1 that's next to the asterisk?
Adjustment related to the legislation passed to treat gas pipeline assets as real property applicable only for these 2 years.
And when you computed the 2024 and 2025 property tax expense amounts, based on this attachment, you reduced the expense by $685,966 and $818,091 respectively, due to the effects of the legislation that you just discussed, correct?
That is correct.
And the legislation that you cited to in this response authorized the Kentucky Department of Revenue to value pipelines as real property assets instead of tangible property assets for the tax years 2024 and 2025. Is that your understanding?
That is my understanding.
And are you aware that recent legislation just became law and it's regarding what you are referring to here?
That is correct.
So you are aware of House Bill 775?
Yes.
And is it your understanding that based on House Bill 775, that just became law on March 27, 2025, that it now provides pipelines can be designated as real property for 2026 as well as future years?
That's correct.
So based upon House Bill 775, do you agree that Duke Kentucky's property tax for 2026 should be downward adjusted?
So let me caveat, because the answer is no, but it's yes. So let me explain. So that, can you see the 17,213,614? Which is the property tax for 2026?
Yes.
That includes the adjustment for that reclassification to real property. We already included it in our estimate. So it includes it, yes, but it doesn't need another adjustment because we already included it in that number. We were expecting to have the We were expecting the legislation to pass.
Okay, so your testimony today is that the downward adjustment based on House Bill 775 is already included in the $17,213,614 number.
That's correct. We
Even though
verified
you
that.
did not show the separate adjustment by line item like you did for years 2024 and 2025.
That's correct.
The Attorney General's office will issue some post-hearing discovery on this, probably asking for an updated attachment here showing that line item adjustment, just to make sure our experts agree with the calculations.
Okay.
And that's all I have today. Thank you.
Thank you. Staff.
I just had a question about the corporate alternative minimum tax. Under what circumstances would that apply? Or why does that apply to the Duke Holding Company?
So the corporate alternative minimum tax, right? It applies to corporations that have adjusted financial statement income, right, of $1 billion or more. And it is applied at the consolidated level for taxes. Okay, so when Duke Energy files its consolidated return, it's above the $1 billion, and so it is subject to that calculation.
Is it only subject to that calculation if tax expense is below, if the holding company's tax expense is below a certain amount?
So just let me clarify one thing, because you said holding company twice.
Okay. Yeah.
It is consolidated taxable income, which means all of our regulated entities added together,
Okay.
not just the holding company. Because when you say holding company, there is a company at the top that is a holding company, and then there are the regulated entities that are underneath it. They all get added together to look at whether Duke Energy makes $1 billion or more in the FSI.
And is that because you're filing on a consolidated return?
That's because we're required to file on a consolidated return, and this adjustment is looked at a consolidated level per the law, the federal income tax law.
And back to when it would apply when the overall tax expense is below a certain amount for the consolidated companies? Or below a certain percentage?
The tax only applies, the tax is calculated once you get to that threshold. So once you get to above $1 billion, right, then you calculate the threshold. Then you calculate the tax when the company is subject to it, right?
But would anyone with gross income of over $1 billion be subject to it? Or if they paid, if the consolidated companies paid, taxes at a certain level, would the alternative minimum tax apply? Or are there circumstances where it wouldn't apply despite gross income meeting that threshold?
It would get calculated no matter, once you're above the threshold, it gets calculated. When you say apply, if your regular tax liability is higher than your corporate alternative minimum tax, then if you're saying it doesn't apply then because you're not subject to it, that would be right.
That's what I'm wondering. What percentage does your regular taxable income need to be for the corporate alternative minimum tax to actually increase your tax expense?
Well, it depends on different factors in the calculation, and there's not a percentage. I mean, remember your corporate rate, right, is 21%, and this minimum rate is 15%, but there's different factors, right, that go into the calculation, in order to figure out whether you're in that AMT situation or not.
And how do you allocate the corporate alternative minimum tax to the various operating companies?
So the way, let's talk just about Kentucky specifically, right? So the way we allocate it is we calculate the entire corporate tax. Let's say that would be $100. And then we calculate the entire corporate tax without Kentucky in it. Let's say that's $96. And so Kentucky would be allocated $4. So it's a with and without calculation, and that's, we follow the federal law on that.
Okay. How does the, could you just kind of give an explanation of how the corporate alternative minimum tax results in the deferred tax asset?
Sure.
And how does that deferred tax asset, how does that would that ever be extinguished for rate-making purposes?
Understood. Okay, so the reason it establishes a deferred tax asset, right, is because when you calculate your tax, right, your corporate alternative minimum tax, and let's say there's that $4 that we talked about that DE Kentucky got allocated, right? What happens is automatically you get a credit that you can use against future taxes when the corporate alternative minimum tax falls below regular tax, so that you can use that credit against regular tax to bring you down. So that $4 is a temporary tax that you will get back in the future. That's why it's a deferred tax asset. So it's only a timing item, no different than a lot of the other timing items.
So would that timing difference ever be reflected in rates?
That timing difference, because it's deferred tax asset, is reflected in rates.
I guess I mean as it's reversing.
As it gets reversed, it comes out of your rate-based calculation then.
And I apologize, I should have been more specific. Would it ever affect tax expense in rates as opposed to rate base?
Not under the current scenario, because it is, we do full expensing, current and deferred. So the way your rates are calculated, right, it will not affect it, no. Not your cost of service, if that's what you're asking.
Yes. Is there a corresponding liability associated with it, or deferred tax liability?
No, not directly offsetting it. I mean, you could attribute other deferred taxes, I guess, to offset that, but I'm not sure, you can't specifically find one. It's not a one-for-one item.
And you said earlier that you have to do the consolidated return. What makes it so that that's a requirement that you do the consolidated return?
So when your corporate parent owns 80% more of a subsidiary, it has to file all as part of a consolidated return. Since we own 100% of DE Kentucky, it has to file with the rest of the companies that we own more than 80% of.
And is that true of all of the corporate subsidiaries that make up the consolidated return?
Are you saying are all our corporate subsidiaries owned 80% or more?
Such that they're required to appear on the consolidated return, yes.
They are all on that consolidated return, yes.
But are they all required to be on there? That's what I was asking.
If they're owned 80% or more, yes. The reason I answer it like that is because we could own a company, just like you go out and buy stock. Duke Holding Company could own a fraction of a percent of a company, right? Mm-hmm. We don't have to consolidate that company even though we own a small piece of it. So that's why it has to be answered in that way.
Well, I guess I'm actually asking not for the rule, but the extent to which the subsidiaries actually are required to be on the corporate return. Like, is there a portion of the like, say 15% of the subsidiaries that appear on the consolidated return, you know, you don't own 80%, so they wouldn't be required to be on there, is that correct?
If there were subsidiaries that I did not own 80%, that's right, they would not be required to be filed in that consolidated manner.
Do you know if there are such entities that appeared on the consolidated return?
Not, no, they could not be.
Oh, they can't be on?
Yes, yes.
Okay, okay. So I guess I misunderstood. I thought in order to appear on the consolidated return, you have to include them if it's over 80%, and you can't include them if it's under that.
That's right.
Okay, okay. I don't have any other questions. Thank you.
I don't have any questions either. Redirect?
Just briefly, thank you. Mr. Panizza, you had some discussion with staff just now about the corporate alternative minimum tax. Do you recall that?
Yes.
And the fact that that's created by the consolidated, it's a tax effect of the consolidated Duke entities. Is that right?
That's right.
Are there benefits to Duke Energy Kentucky for filing a consolidated tax return?
Yes, there could be benefits. It depends on the year, obviously.
Sure. Could you give some examples of the types of benefits?
Sure. Usually we find attributes to be benefits. These are attributes like losses or some type of credit carry forward where on a separate company basis, the separate entity like Kentucky would not be able to use it as fast or at all. But with a consolidated return, a lot of times there are other entities that are able to help use that faster. And what that does is the DTA that's sitting on your books by using it faster comes off, right? And it helps the rate base calculation.
Okay, so to what extent does Duke treat the benefits and then the consolidated alternative minimum tax symmetrically, in the sense that both are included in allocations to Duke Energy Kentucky when they apply?
Well, can you rephrase that
Yeah,
one more time? Sorry.
No, that's okay. That was a complicated question. To what extent does Duke treat both the benefits and the costs of the consolidated return symmetrically for Duke Energy Kentucky?
Right. So we treat benefits and costs in the same manner. Meaning, if it's a benefit, it gets into the rate-based calculation, and if it's a cost, it gets in there. And, I mean, if you're asking if they were to offset, if we had both, they would.
Thank you. And then just lastly, you were asked about how the tax is allocated to Kentucky and Duke Energy Kentucky.
Yes.
And you used an example of Kentucky, and I just wanted to clarify for the record. Does Duke allocate to the corporate alternative minimum tax to Kentucky the same way it does to other operating utilities in its family of companies?
Every family member gets the same calculation.
Thank you.
With and without.
That's all I have.
Okay, any recross?
I do have just a few. Mr. Panizza, in the pending case, Duke Kentucky's tax expense that's included in the revenue requirement, that's calculated on a standalone basis, correct?
That, when you say, so we're going back to the property tax, just so I'm clear, right?
No, we're talking about what you've just been talking about with
We're
staff
gonna
and with
stay
your
with
council.
AMT, I'm sorry.
Yes, the
Okay,
CAMT.
sorry, yes, all right, let's go back then.
So in the pending case, Duke Kentucky's tax expense that's included in the revenue requirement, that's calculated on a standalone basis, correct?
That is calculated on a standalone basis. You're talking about the with and without calculation?
Yes.
Yes.
But Duke Kentucky is asking the customers to pay a consolidated income tax cost in this case, correct? The CAMT DTA.
It is when you say a consolidated cost, we're asking them to pay for their particular share that they're contributing to a cost that happens for our entire group.
And Duke Kentucky did not include any consolidated income tax savings that would reduce the standalone income tax expense in this case, correct?
What type of savings are we talking about?
Well, isn't it accurate that without the parent company Duke Energy having the AFSI, the adjusted financial statement income, I believe above $1 billion, Duke Kentucky's customers would not have to pay those tax costs, correct? And then there's also tax savings that could happen at the consolidated parent level, but it's not trickling down. That's where I'm coming from with that question. It seems like the costs are being pushed down, but any savings aren't actually being pushed down too.
I'm just gonna object real quickly because there were a lot of questions and comments in that. If we could just narrow it to a question, that'd be great.
My original question,
Which was,
that in this case, Duke Kentucky did not include consolidated income tax savings that would reduce that standalone income tax expense.
to my knowledge, there weren't any particular savings that come to my mind that would have reduced that minimum tax, if that's what you're asking.
Thank you, Mr. Panizza. I have no further questions.
I guess I do have one question, and bear with me because I barely do my own taxes, okay? So just understand that's the level, but, okay, so let me make sure I understood the discussion you just had. The corporate alternative minimum tax gets paid if it is higher than the normal tax. It's whichever one's higher.
That is correct.
Okay. So in this case, I have to assume that because you're trying to allocate costs to DEK, that means the CAMT was the higher of the two numbers.
Yes.
Okay. Are there occasions where the corporate parent pays taxes to the federal government at a percentage that is lower than the taxes that DEK takes from its ratepayers and passes up to the corporate parent?
And when you say percentage, what do you want to look at there?
Well, okay, so let me try to break this up. So
Yeah.
Embedded in rates
Mhm.
is a gross up, embedded in DEK's rates is a gross up for taxes, correct?
Yes.
And am I right that is it based on a 21% tax rate?
Federal.
Yes,
Yes.
21%.
21% for federal.
So is there ever an occasion where because of losses on a total consolidated basis or because of tax breaks that are eligible for certain savings, or, again, remember, I've told you, like, my level of taxable knowledge is minimum.
Right.
What I'm trying to understand, is there ever an occasion where the ultimate tax rate paid by the corporate parent to the federal level is less than that 21%?
So technically, the answer is no.
Okay.
We always pay 21%. Just don't get confused because there are certain additions and deductions that happen at each different level,
Okay,
excuse me, of the company, right, where your cash taxes might be lower, but not your rate that you pay to the government.
because you're at a consolidated level, you're able to take advantage of certain puts and takes that affect how you're calculating the number upon which that 21% is calculated.
They are things that you can subtract from income, in other words, to bring your taxable income down lower.
It lowers the number
It
upon
lo-
which you calculate the 21%.
That is correct. That's all that's lowering, not the
Not the rate.
21%, not the rate.
Not the-
Yes, the
okay.
rate is the same.
Okay, and so to the extent that there is, I'm trying to follow up on the concept of this question about the benefits flowing back down versus the costs of the CAMT flowing down to DEK. So that's, I'm getting there in a roundabout way, so I apologize for that. But if there is some savings that allows you to reduce the available income on what is filed at the consolidated level, is that deduction or reduction ever used to say, you know what, DEK, we had this huge write-off up here at the consolidated level. Instead of paying us X, we're not gonna take that much from you, we're gonna take a little less.
So that can trickle down, right? It just depends on what's coming through on DEK's return.
My question is because you file on a consolidated basis, right?
We do, yes.
And the CAMT is something that is going to affect DEK, even though standing alone, DEK is not subject to the CAMT, right?
That's correct.
Okay, so there is a situation where ratepayers could be paying more in taxes by virtue of decisions made by the corporate parent.
If you're saying decisions that the business makes, everybody is subject to the decisions that the business makes in total.
Who's the business?
The entire company's business.
Do you mean Duke Energy Inc.?
And subs.
But you agree with me that standing alone, DEK is not subject to CAMT?
On a separate company basis, it would not be subject to AMT if it filed as a complete separate filer,
Okay,
if it was allowed.
but my point is that the only reason CAMT is triggered is because of the consolidated aspect of the Duke Energy Inc. and its subsidiaries filing, being required to file on a consolidated basis.
That's right, whether it's a benefit or detriment, that's the way they have to file, and that's what's happening.
Okay, so what I guess I'm trying to understand is, as I understand the way rates are calculated in Kentucky, currently, not with respect to the alternative minimum tax proposal in this case, but going in, rates are always calculated based on a 21% gross up.
You know, you're in cost of service land,
100%, but
which this doesn't affect.
but you understand that there is an embedded amount in rates to allow DEK to pay money up to the corporate parent for purposes of federal income tax.
That's correct.
Okay. And so what I'm trying to understand is it sounds like it's possible where some years we're gonna have a situation where the alternative minimum tax applies, and it's possible other years it does not. Is that fair?
That is fair.
Okay. So
And
there's
when it doesn't apply, it may get reduced even.
But
That's what we were talking about.
What gets reduced?
The deferred tax asset. That's really all we're talking about here.
Okay.
You have a deferred tax asset, that's what you're getting at.
Okay, and what I guess I'm trying to figure out is, are there ever any other occasions where, because of beneficial tax situations that occur for Duke Energy Inc., or based on the consolidated filing, whether or not it flows directly from DEK, that those benefits are ever flowed back down to DEK?
That's what we were talking about before.
Okay.
With the NOLs and the other tax attributes.
Okay.
Yes, that does occur.
Okay, that's what I was trying to make sure. And
Yeah.
is all of that gonna go into the tax deferral that we're talking about? Or have I misunderstood?
The deferred tax asset then would be reduced, yes.
Okay,
That is correct.
okay. That's what I was trying to understand. Thank you for bearing with me as I asked you
No,
some
you're
of these
good.
questions.
Sorry, I didn't understand it originally,
Nope, that's.
where you were going.
No, that's okay. Thank you so much. Those are all the questions I have.
Okay, now I've forgotten what I.
No questions, thank you.
Recross staff?
I did have just a couple
Sure.
follow-ups. There was discussion when you were talking to your council about the tax benefits that flow to Kentucky customers. And I understood from reading your rebuttal testimony that one of the benefits is if there are book tax timing differences for Kentucky as a regulated entity, that would result in deferred tax liabilities, but for whatever reason, because of the size of those deferred tax liabilities or the offsets that form them or they arise from, Duke couldn't use the full value of those offsets, and therefore that would typically result in a deferred tax asset arising from a net operating loss carry forward. Is that correct?
I think the testimony was trying to actually talk in the other direction. I
And
think it
now-
was talking about deferred tax assets that would be reduced.
Yeah, and I was going to get to that. I think
Okay.
that's what you were talking about. So on a
Yeah.
standalone basis, if you were calculating Kentucky's tax expense and the, I guess, tax effects of various timing differences, if you had, for instance, if you used a lot of bonus depreciation in a particular year, you might have significantly more expense that you can write off for tax purposes than you would be able to for book purposes. That would result in a deferred tax liability, but then a portion of it would result in a corresponding deferred tax asset to the extent that you couldn't use that offset to defer your taxes, correct?
That is correct.
And what you were saying in your rebuttal testimony is one of the benefits is that if you're doing it on a consolidated basis, that deferred tax asset would increase rate base, the liability would offset rate base, and doing it on a consolidated basis, the other entities within the consolidated return would use a portion of that deferred tax asset, or all of it, such that the full deferred tax liability would be reflected for Kentucky customers. Is that what you were saying?
That is correct.
Just a question about how that works.
Mhm.
Does the full deferred tax liability remain on the books of Kentucky, Duke Kentucky?
That's right.
Okay, so it doesn't flow up and then get allocated out?
No.
And with respect to deferred tax assets that are generated in that manner, I understand they can flow up and potentially be used, and Duke is then effectively reducing rate base by eliminating that deferred tax asset at the Kentucky level. Let's imagine there's another regulated entity over here that has a large deferred tax asset arising from similar circumstances. Is there any circumstance in which any portion of that would be allocated to Duke Kentucky? Or does it only flow in one direction?
No.
They can use it, but it'll never be allocated over.
That's right. You and the holding company are the only people like conversing. Now, they have their own number, you have your own number. If we only use 80%, then we use 80% of yours and 80% of whatever the other regulated utilities was.
Okay.
That's it. And you
Yep.
get your cash.
Okay, but the deferred tax asset isn't flowing up to the holding company and then be allocating down, such that deferred tax assets due to net operating losses in other operating units could be moved over to Kentucky. That wouldn't happen.
That's right. You cannot take one of the other regulated deferred tax assets and put it on Kentucky's books, and they can't take yours and put it on their books.
Okay.
That does not happen.
Okay, thank you.
Commissioner Erdmann, anything further?
Oh, no, sorry.
I didn't either. Any reason why this witness couldn't be excused? Thank you, sir.
Thank you.
All right. Counsel, call your next witness.
Thank you, Your Honor. The company calls Thomas Heath. Oh, excuse me.
Good afternoon, Mr. Heath. Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please be seated. Tell us your full name and business address.
Sure, my name is Thomas J. Heath Jr. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
Okay, counsel.
Thank you. Mr. Heath, would you please state your position with the company?
Sure, I'm a corporate finance director in our treasury group.
Thank you. Did you cause to be filed direct testimony, rebuttal testimony, and responses to data requests in this proceeding?
Yes, I did.
Do you have any corrections to that testimony or those data request responses at this time?
No, I do not.
If I asked you the same questions today that were stated in that testimony and data request responses, would your answers be the same?
Yes, they would.
And is it your intention that all of that information be entered into the record today?
Yes, it is.
Thank you. Witness is available for cross-examination.
Thank you. Office of the Attorney General?
No questions.
Thank you, Mr. Bain.
No questions, thank you.
Ms. Grumman?
Very briefly, good afternoon, Mr. Heath.
Good afternoon.
were you either listening in the holding area or in the room, when counsel for the Attorney General asked Ms. Spiller about the timing of the decisions in the company's last rate case?
Yes, I was.
Okay, so you understand that there was a decision, from October 2023 that was amended on rehearing in July of 2024?
For Kentucky.
For Kentucky,
Yes.
correct.
Yes.
And the reason I ask that is, can I ask you to turn to page 9 of your direct testimony? I read the Q&A there beginning at line 10 that sort of, after the initial rate case decision and in the midst of the commission's reconsideration, Moody's upgraded the outlook for Duke Energy Kentucky from
They-
negative to stable, correct?
They changed the outlook from negative to stable.
And that's a positive change, correct?
It is, yes.
And was there any change for S&P, or did it just hold firm at the BBB plus rating and stable outlook?
Correct. They never put Kentucky on a negative outlook, so the rating was unchanged. It had been triple B plus stable, and it remained triple B plus stable.
And I don't recall that you addressed it in rebuttal, but do you know as we sit here today whether those remain the ratings for Moody's and S&P?
Those do remain today. In my testimony, I referenced these May 2024 reports that both agencies put out. Those are the latest reports that they have issued. We do
Okay.
expect reports in the next couple weeks or early part of June from each agency.
Okay.
I do believe those ratings will hold, though.
And as I recall, there was a discussion in the last rate case about FFO to debt.
Correct.
And is it fair to say that at present you are are you above that 17% FFO to debt number?
We are above the 17%, which is the downgrade threshold at
Right.
Moody's. Yes.
And am I right, were you below that 17% going
We had
into the
been-
last?
Yes, we had
going
been
into the last rate
below,
case.
correct. We had been below that 17 for a number of years consecutively. And that was putting significant pressure on the ratings, which is why Moody's put us on a negative outlook, pending the outcome of the rate case.
And then the rate case came out, the commission reflected the need to ensure that, and you got an ROE of 9.75 in that case?
I believe that's right, yes.
And can you tell me now what your current FFO to debt range is?
Yeah, if you look at, in my, I think it was in a discovery response to, I believe it was to the AG, we did provide rating reports from Moody's and S&P. So if you look at those, our FFO to debt in 2023, in 2023, with the impact of the rate case, did increase to 21%, I believe it was, 21%. And it's also around 21%, I believe, for full year 2024.
And so
Now, we do expect those over the next several years to kind of mitigate some and be back down around the 18 to 20% range.
And is the statement that you just made based upon the company's going in position into this case, or does that make any assumptions about the request in this case?
It is based on our forecast that we provide to Moody's, and Witness Hudson could talk about more, but what was in that forecast that was provided to Moody's.
Okay, so with respect to the Moody's decision, the decision to improve the company's outlook from negative to stable, that decision was made when the company had been awarded a 9.75% ROE. Is that correct?
If the timeline that you discussed is true, that's correct, yes.
Are you aware that when it came to the rehearing, that rehearing issue did not involve the return on equity awarded in the commission's October 2023 decision?
I'm not familiar with the specifics of the rehearing. But,
Okay. And so then in terms of the record, it will you and I agree, it will speak for itself.
Sure.
And so if, looking at lines 19 to 20, when S&P affirmed its outlook for Duke Energy Kentucky, if in fact the 9.75% ROE that was awarded to Duke was awarded in the fall of 2023, then S&P would have been affirming its rating with knowledge of
Correct.
that return on equity decision. You
Yes.
agree with that?
Yeah.
And it's fair to say that, would you agree that neither S&P nor Moody's viewed the outcome of the last rate case as negative?
No, they did not view it as negative.
Okay, you note on page 17, line 18, there's line 17, it begins a sentence that says, equity investors expect utilities like Duke Energy Kentucky to recover their prudently incurred costs and earn a fair and reasonable return for their investors. The company's proposal in these proceedings supports this investor requirement. Did I read that correctly?
Yes.
Okay. And so, are you making any statement or offering any testimony in this case as to the reasonableness of the ROE that was proposed by company witness Nowak in this case?
Yeah, at the top of that page, I say that the company supports Mr. Nowak's analysis and is requesting 10.85% ROE.
I understand the company supports it. I'm trying to figure out if you as a witness are offering any testimony that would verify the accuracy of this, the calculation of it, the reasonableness of it.
Other than that statement, I don't believe.
Are you, having made that statement, are you aware of any, of the number of utilities in this country that have an ROE as high as the one that Duke Energy Kentucky requests in this case?
Not offhand, but no.
Would it surprise you to learn that only one investor-owned utility, to my knowledge, has an ROE higher than the 10.85% requested by Duke Energy Kentucky, and it's a utility in Alaska?
It depends on when those rate cases were litigated and settled, and what their test periods were, and what market conditions were at the time that those ROEs were set.
Did you happen to review the testimony of Walmart witness Lisa Perry in this case?
No, I did not.
Give me just a second. Your Honor, I'd like to mark a document just for the record. I can pass it around. It's a blown-up copy of the chart that's in Lisa Perry's testimony. And I think it comes from her work papers, LVP-2, but I've blown it up because it's fairly hard to see, and I'm happy to pass a copy around. Can I have this marked as Walmart Exhibit 2? Thank you.
Mark this?
Yeah, I would, just because I think it's a blown-up version of what's in Ms. Perry's testimony, but I think it'd be helpful to mark it as Walmart Exhibit 2.
Your Honor, if I may, very quickly, Ms. Perry's testimony has not been entered into the record officially yet, and this witness has already said he didn't review it or have information about ROEs for other utilities. So I don't know that this witness is capable to authenticate or otherwise address this exhibit at this time.
If she moves to admit it, we will definitely take that up.
But Mr. Heath, can you take a look at the document there? Do you see on that second line, it says Duke's requested ROE?
I see that, yes.
And then do you see right above it that the only ROE awarded that's higher than that is Alaska Electric Light and Power.
I'm going to renew my objection just because he can, the witness can speak to what is on the page, but not whether it is, not verify it is factually true or not.
Are you gonna attempt to lay a foundation to admit it?
Right now, no. I think that, you know, the reason I'm attempting to explore this with him now is that I just wanted to go over with him his, you know, he made statements about ROEs and supporting the ROE in this case, and I want to know, you know, I would have expected him to say, no, I'm not supporting this, our witness Nowak does that, but instead he told me that he is supporting it, and he pointed to me to his testimony, and so I am attempting to explore how he has any level of reasonableness for that assumption.
You can answer if you know.
The statement I make there is supporting his recommendation based on my review of his testimony.
Okay, so you haven't attempted to independently verify whether his recommendations are reasonable?
Other than reviewing his testimony, no, that is not he's the ROE witness, not me.
Okay. And you haven't attempted to look into the marketplace to see what other utilities are being awarded?
Not in depth, no.
Are you looking at it at all?
Yes.
Okay, so going back to my original question, when you look at whether it's in depth or not, what are you looking at?
I'm mainly concerned of what the ROEs that other Duke entities have been awarded. It's part of my responsibilities at Duke.
So are you aware that the highest awarded ROE to any Duke subsidiary is the 10.3 that was awarded to Duke Energy Florida?
Recently, yes.
Well, currently in existence, that's the highest awarded ROE for any regulated Duke affiliate.
It is, but I think if you just pick numbers without context of what is the background for those numbers, when were those numbers set, when were they awarded, what was the length of the regulatory proceeding, are there forward test periods, are there historical test periods, all those things have to be taken into context when looking at and comparing ROEs. I mean, I don't know when this Alaska ROE was set, right? There's nothing on this page that tells me when it was set.
What does a future test year or forecasted test year what does that have to do with the ROE analysis undertaken by Hope and Bluefield, as done by Mr. Nowak in this case?
He would have to comment on that.
So you don't know, when you make the statement that it's relevant as to whether it's a forecasted or future test year, you don't know whether that has any relevance to the calculation of the ROE?
I know there are a lot of factors, including those things, that go into assessing ROEs.
So what relevance does the test year have to calculation of the appropriate ROE?
Objection asked and answered outside the scope of this witness's testimony.
Your Honor, the witness opened the door. I've asked him what relevance the test year has. He says, I don't know. That's Mr. Nowak. And he says, but I know there's a lot of factors of which the test year is. So then I've asked, well, what's the relevance of the test year to the calculation of the return on equity? I didn't introduce those facts, he did.
If you know the answer, sir, you can answer.
I've got nothing else to add from what I've previously said.
So then other than a generic belief other than a generic thought or belief that the test year factors into the ROE, you can't point to anything specific for that?
I know when ROEs were set, what were the market conditions at the time they were set, those things matter.
And is the market conditions relevant to the test year?
Yeah, I think to some extent they are, yes. Whether are we looking at market condition, well, are we looking at market conditions at the point that we're requesting the rate case is relevant.
Well, in a rate case, you're always looking at market conditions at the time of the rate case, correct?
Correct, but whether we're looking at market conditions today in the context of this rate case or market conditions at the time that we did the 2022 rate case, those are different market conditions, and those are going to dictate and derive different ROE requirements and recommendations.
So you're saying that in 2022, your ROE witness would have looked at market conditions in 2022, and in 2024, 2025, your ROE witness is going to look at market conditions for 2024 and 2025?
Yes.
Is there ever an occasion in recent time where Duke Energy, Inc. has given an equity infusion to DEK?
In 2022, or early 2023, there was an equity infusion from Duke Energy Ohio to Duke Energy Kentucky, which is Duke Energy Kentucky's parent.
Right.
Correct.
There's one additional layer, right? Okay.
Yeah.
But am I correct in looking at your testimony at page 18, line 19, that most of the time DEK funds its operations by retaining earnings?
Yes, and borrowings.
And those borrowings are done at the DEK level?
Correct.
Thank you, Mr. Heath. Those are all the questions that I have.
Yeah, just a few questions. So, Mr. Heath, if you could refer to your rebuttal testimony, pages 21 through 25, discussing the debt markets.
Rebuttal 21 to 25?
Yes. Section 6. Oh, I'm sorry, direct.
Okay.
I misspoke. Yeah.
All right. I said there was
Yeah.
on page 21.
My apologies. Yeah.
All right.
Okay.
Okay.
So, first, is my understanding from your testimony that Duke Kentucky primarily relies upon the private placement debt market, section 4A2?
That is correct.
All right. Can you just explain why Duke Kentucky is limited to that private placement debt market?
Yeah, I would say we have historically been limited to that 4A2 private placement market. And there's a discussion there about these different options, right? The fully registered market, the 144A private placement market, and the 4A2 private placement market. And so the 4A2 market is really the market that's most readily available for issuances of the size that Duke Energy Kentucky has historically done. And so those have been, $100 million or less. We did do a transaction in 2024 that was $225 million. We did that in the private placement market. When you think about the 144A market, there are more investors available there, but generally they require a minimum size of $300 million for secondary market liquidity. And so we've not been at a point where we could issue $300 million worth of debt at Kentucky in a single issuance. So we've not been able to use that 144A market. That's why we've kind of relied on the 4A2 private placement market. I do have a statement in here, though, that we, as the financing need at Kentucky continues to build, as we're doing more and more capital, deploying more and more capital in the jurisdiction, that 144A market could be something that we can have access to. That would likely require us to bridge and not do we try to do financings every year in most of our opcos, including Kentucky. But to access that 144A market, we would only do a long-term financing probably every other year, and we would use short-term debt funded either through money pool borrowings, through the other opcos at Duke Energy, or through the Duke Energy Holding Company, to kind of bridge to that larger financing. Or we could do something like a term loan at Duke Energy Kentucky with a club of banks.
Okay, building up to the larger
Building up
market.
to that $300 million long-term institutional type product.
And understanding that Duke Kentucky is currently limited by the smaller amounts that they'd be seeking. So could you just go over basically the advantages of the public placement debt market compared to the private?
The 144 private placement.
Or the public, I think SEC.
So the SEC
regulated.
registered market
Yeah.
is, I can talk about it, but it's not something that's available to Duke Energy Kentucky because we're not a publicly traded company, right? So our other operating companies, Duke Energy Carolinas, Progress, Indiana, Ohio, Piedmont, are all fully registered and listed public companies, and they have access to that SEC public debt market. Again, there are minimum size requirements there, usually $300 million as well in that market, but that is the broadest market that's available for debt securities. So institutional investors participate in that, individual debt investors can participate in that market. But we would have to be a publicly registered and listed entity. There's compliance costs and ongoing reporting obligations that are cost prohibitive to allow Kentucky to do that, though.
And you talked about pooling with other Duke affiliates for the what was it, the 401, the larger private debt
So,
market.
so the 144A, I was saying that we could do a long-term debt financing in that market maybe every other year. That would exceed that $300 million range, right? But in the interim, we would borrow short-term debt either through our money pool program, which was our ability to borrow from affiliates who have excess cash, or through a term loan with directly contracted with a group of banks.
Okay.
So that's the affiliate type. It's not pooling a debt need with another opco to go to that 144A market. Does that clarify?
Yeah, yeah, I think I understand. And then, would that kind of arrangement be possible for the SEC registered debt market that you're discussing, like a similar arrangement that would get you to the larger private financial market?
Again, we would have to take on additional compliance obligations, reporting obligations to do that, to be able to access the SEC public market, and those would be additional cost to do that.
Okay.
So the 144A market allows us to, it's not fully registered like the SEC, so we could achieve many of the benefits of the public debt market without having to be a publicly registered entity. So it broadens the investor universe, and the market execution is much more streamlined than the 4A2 private placement market. So we could achieve many of the benefits of being a public entity, but only going to the 144A market.
Got it. Okay. And then one more on this specific topic. If you could just go over some of the ways that Duke is currently trying to reduce the cost of debt in its current market placement. So you spoke about potential arrangements for the larger private market, but in any other.
Yeah, so we have the benefit, Kentucky has the benefit of access to short-term borrowings at more economic rates through its participation in, through its belonging to the larger Duke Energy entity, right? So we have a very large commercial paper program at our holding company. That holding company can borrow commercial paper on behalf of the utilities and pass that cost through. That's a vehicle that's not available to Kentucky on a standalone basis. They can borrow through the money pool, which is at more economic rates than they would be able to borrow on their own. Again, those are short-term financing vehicles. One thing that is talked about in my testimony is the termination of the prior receivables financing program. We had determined that was no longer achieving the financial benefits that it had previously achieved, and so we terminated that program and replaced those borrowings through the money pool at more economic levels. And
that actually was where my next set of questions were going to go into, were the accounts receivables financing program. I know in your testimony, and I believe it was pages 25 through 28 is that section.
Okay.
You discuss generally that the program was not as cost effective, and that eliminating the program was better or more cost effective for customers. I just wonder if you could expand on that a little bit and go into a little bit more detail.
Sure. So we've always kind of benchmarked that program, the cost of funds under that program, to other financing options, including our commercial paper program and longer-term debt borrowings through the private placement market that was available to Duke Energy Kentucky. Historically, if we go back 5 years or 4 years even, that differential was beneficial, right? So the cost of funds under that receivable financing program was lower than what we could borrow in other channels, other options, right? But as the yield curve kind of got inverted over the last couple of years, and short-term rates have been higher than longer-term rates, we continued to take a look at that program. When I was here in 2023 testifying in the prior rate case, at that time, the cost was marginally higher than other options. We continued to maintain the program because of diversification that it brought to our lending base. So those 4A2 private placements that we issue at DEK, and even if we did the 144A market, those are fixed rate borrowings from large institutional investors, so pension funds, money managers, insurance companies. So this receivables program allowed us to borrow floating rate debt from banks. So the diversification in terms of the interest rate and the diversification in terms of the investor base, right? And so we believed, even though it was marginally more expensive, there were still benefits to having the program. There were some recommendations in the rate case order in 2020 that came out in 2023, 2024 that encouraged us to take another look at that program. And so we did that. We took that to heart. We did our typical review of that in terms of borrowing costs. But we also recognized that there was some administrative cost to administering that program, or cost to administer that program. Time that I spent on a monthly basis, time that our cash management team spent on a monthly basis processing interest invoices, time that our accountants spent on that program, time that our billing folks or our accounts receivable team spent on aggregating data to provide to the banks that lent against those receivables to demonstrate that we could support the outstanding borrowings with available receivables. And as we looked at that, when we saw that the costs were getting more expensive, right, as the interest rate curve continued to be more inverted, and then as we went through and kind of polled different parts of our organization, we realized that the administrative burden that we were bearing, that Duke Energy was bearing to support that program, was much more comprehensive or more extensive than we understood it to be. So there were a lot of administrative efficiencies to be achieved by elimination of that program. We also were able to lower the interest cost, and those are the kind of factors that we looked at.
Is there a cost benefit analysis in the record, or one that you could provide in post-hearing data request?
Yeah, there is, as part of data request, there is a spreadsheet that shows the cost compared to commercial paper and other long-term borrowings, and there's also a presentation in response to a data request that we presented to our management team around the decision to terminate the program, or the request to terminate the program. And that is in one of, I believe that's in an AG data request. I can flip here real quick. It is in response to AGDR 02042.
Thank you. That's all the questions I have.
Okay, you asked the question I was going to ask. Okay, and I don't have any questions either. Redirect.
Thank you. Just a couple of questions. You started out your cross with counsel for Walmart, talking a little bit about the credit rating agency's opinions in May of 2024. Do you know, Mr. Heath, whether those rating agency opinions were set based solely on ROE, or were other factors included in that?
No, I mean, the agencies take a comprehensive view when they do their ratings, and there's some of that I've discussed in my direct testimony about the factors they look at. Some of that is financial measures, some of that is qualitative measures as well, including things like the constructiveness of the regulatory environment, track record of recovering costs, our ability to deliver results as we've presented them to the rating agencies, and those sorts of things.
And when you talk about those things in your testimony, are those solely, considerations of the moment, or were the rating agencies also looking ahead to potential challenges and opportunities?
It is both.
Thank you. That's all I have.
Okay, recross.
No questions.
Recross.
No questions?
Staff.
No questions.
Any reason this witness couldn't be excused? Thank you, Mr. Heath, you're excused.
Thank you.
Okay. We have a 4 o'clock stop time today because they're gonna start some pretty noisy construction on the other side of that wall around 4. We hope, yeah, we hope they're coming, because we'd love to get back in our big courtroom. We still have half an hour. Would you like to call another witness?
Yes, Your Honor, the company is happy to call Michael Adams, and we'll determine.
Oh, I'm so sorry.
It's a small courtroom.
Yes. And I would defer to the other parties that how much question time they may need.
Okay. We'll get as far as we can then. Hello, Mr. Adams. Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury? Thank you. Would you please be seated and tell us your full name and your business address?
My name is Michael Adams. My business address is 293 Boston Post Road West, Suite 500 in Marlborough, Massachusetts.
You'd be surprised how often that's a hard question.
I don't ever go there, so
People don't always know. Counsel.
Thank you. Mr. Adams, would you please identify for whom you work and in what position?
I am the Senior Vice President with Concentric Energy Advisors.
Okay. And did you cause to be filed in this case both direct and rebuttal testimony as well as data request responses?
I did.
Do you have any corrections to your testimony or data request responses at this time?
I do not.
If I asked you those same questions that was in those documents, would you have the same answers today?
I would.
And is it your intention that all of that information be entered into the record today?
It is.
Thank you. Mr. Adams is available for cross-examination.
Thank you. Ms. Gill.
Thank you, Chair. Good afternoon, Mr. Adams.
Good afternoon.
Is it your understanding that Mr. Futrall recommends that Duke Kentucky's collection lag days in the cash working capital study be based upon the 2024 data because the 2023 electric and natural gas data was impacted by a short-term spike in natural gas?
That's my reading of what he proposes, yes.
And Mr. Adams, please refer to your rebuttal testimony, page 9, lines 11 through 14, and let me know when you're there.
I'm there.
Can you please read lines 11 through 14 into the record?
The cash working capital studies, at the part you're talking about?
I'm sorry, did you ask me a question?
Yeah, is that where you're talking about a cash working capital? Is that where you want me to
Yes,
start?
that sentence, thank
Okay.
you.
The cash working capital study, as well as the rate test here, should adhere to the matching principle unless there are anomalous conditions that overwhelm the general principle of relying on a matching period for purposes of analyzing leads and lags.
And the sudden spike in natural gas prices was an anomalous condition, correct?
Yeah, I'm not sure that I agree that it's necessarily an anomalous position. I agree gas prices went up. I'm not sure it's significant enough to cause a deviation from test year principles.
Since you used the word anomalous in the rebuttal, would you accept, for purposes of this next question, that the definition of anomalous is inconsistent with or deviating from what's usual, normal, or expected?
I agree that's the definition. I'm not sure that that's what was experienced because gas prices go up and down frequently.
So a sudden spike in price, you don't agree that that's a deviation from a normal price?
I don't know how you would define a normal price. I mean, gas prices change all the time.
You disagree with Mr. Collins' recommendation to include long-term debt interest expense in the cash working capital calculations for Duke Kentucky, correct?
Correct.
Do you agree that long-term debt interest expense is a cash expense?
Yes.
And do you agree that long-term debt interest expense is accumulated normally over 6 months and then paid?
It's paid, but it's paid out of operating income, which is owned by shareholders, not by the customers.
Would you agree that Duke Kentucky's customers pay for the long-term debt interest expense in the customer rates every month?
The cost would be recovered through rates, yes.
And do you admit that you have recommended for long-term debt interest expense to be included in the cash working capital calculations for other utilities?
I have, as I say in my testimony, I follow the precedent of various jurisdictions when I go in to do a study. And I follow that precedent when I perform the study. And in the case of Kentucky Power, which is the one he references, that was a company that had never done a study. And when I was talking to management, I walked them through what the options were, and that's the approach that they chose to follow.
So to obtain clarity, you did include long-term debt interest expense in the cash working capital calculations and your recommendations in the most recent Kentucky Power rate case,
That's
correct?
the first study they'd ever done, and yes, I did.
Are you aware that Duke Kentucky utility affiliates in North Carolina have also included long-term interest expense in their cash working capital
It's a
analysis?
different jurisdiction, so I mean, I was following the jurisdiction that Kentucky Power, that Duke Kentucky is in.
But are you aware?
Yes, I'm aware of it.
I have no further questions.
Mr. Beck?
Good questions, thank you.
And Ms. Graham? No questions.
Yes, I will just have a couple questions for you, Mr. Adams. Good afternoon.
Good afternoon.
Some of my questions were just asked, but I do have a couple, and they're all relating just to your rebuttal testimony. AG witness Collin recommended removing coal fuel and lime expenses and removing the amortization of prepayments from Duke Kentucky CWC calculation. Can you explain again why you disagree?
Because I think the way he's defined them was not appropriately, was not truly what the costs were. I mean, these were just fuel costs that were purchased, and they rightly fit into a cash working capital study.
Can you confirm that they're not being double counted?
I don't know how I would do that, but I've only reflected them once.
And did the lead lag study use billed revenues or book revenues?
I think it was booked, but I can't confirm that.
Just curious, how much of a difference would it make between using billed versus book?
I don't know the answer to that.
Okay. Thank you, I believe that's all.
Okay, Mr. Reagan?
Good afternoon. If we follow up with a DR on that, do you think you could get that information, whether it's book value or?
The last one?
Yeah.
I can try, yes.
Okay, thank you.
Okay.
Yes.
Okay, and I don't have any questions. Redirect.
No redirect, thank you.
In that case, any reason this witness couldn't be excused? Okay, sir, you're excused. Thank you very much.
Thank you for putting up with my voice.
Okay. So as I understand it, the next witness is Nowak, likely to be longer.
So, Your Honor, I suspect Mr. Novak may be longer. Our thought was, we do have several witnesses who either didn't file rebuttal or had virtually no issues, and we thought maybe it would be, perhaps make some sense to take a few witnesses out of order and see if they can.
Yeah. How about, toss out a name and we'll see
yes,
who
I
has
have-
questions.
I was gonna suggest maybe we could figure out if there were any witnesses for whom no parties had
Yeah,
problems.
that's-
Yeah, if we
you
could do
toss
that
out a
generally,
name
that
and
would be
see. Mhm.
great.
I'm just thinking,
Yes,
I don't have any for Weatherston.
I do not either.
Do you have any for Weatherston? None for Weatherston?
Yeah, that sounds like a good one.
All right.
I'll let you get by.
Do you have any for Kira?
Yeah.
Yeah.
Ms. Weathers is just in
Sure,
the
no
hearing.
problem.
What about
Right
Kira?
there.
I do. Okay. Shannon Caldwell. You probably do. Yeah. Does staff have questions for Caldwell?
I don't believe in
I said one.
None for Caldwell?
No questions for all.
Is there a typo?
I don't for Holly either.
I don't, do you have any for Collie?
I think we do. We do.
For Collie?
Yes.
TK
don't.
Christie?
I
Oh,
don't
the
for
rest
Christie.
of the sentence was deleted. Jesus Christ. You got to do one.
None for Weatherston or Caldwell.
Correct.
I don't for
We do
Arnold.
not. None for Christie.
What about Arnold?
No, none.
Okay, do you have any cross for Weatherston, Caldwell, Christie, and Arnold?
No.
Those four don't have any cross.
Did we get through them real quick?
But then we get a little further down the list, and then they need to invaluable service. We're like, you don't know. It's a quarter. It's almost done. That's literally what's going through my head.
Yeah, let's see. Okay. Council?
Thank you. Company calls Danny Weatherston, please.
Ms. Weatherston, would you raise your right hand to be sworn, please? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Tell us your full name and business address.
My name's Danielle Weatherston. My business address is 525 South Tryon, Charlotte, North Carolina, 28202.
Okay, counsel?
Thank you. And I'll note, just for your honors, that Ms. Weatherston does not have her testimony with her, but if we need to grab it, we will. We just, since we're moving quickly, we just brought her up right away. But Ms. Weatherston, would you please state your position with the company, please?
I'm an accounting manager in the DEBS group for the Ohio and Kentucky jurisdictions.
And did you cause testimony and data request responses to be filed in this proceeding?
I did.
Do you have any corrections to your testimony or data request responses at this time?
I do not.
If I asked you those same questions today, would your answers be the same?
They would.
And is it your intention for that information to be entered into the record today?
It is.
Thank you. Ms. Weatherston is available for cross-examination.
I am assuming there won't be any from any parties, but speak up if there was.
No questions.
No questions?
Okay. Any reason this witness couldn't be excused?
No.
Thank you, Ms. Weatherston. You're excused.
Thank you.
Great job.
Caldwell.
Yes,
Pardon me,
the company calls Ms. Caldwell, who we understand the parties do not have cross for as well.
Did you? If you do. Good afternoon, Ms. Caldwell. Would you please raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please tell us your full name and your business address.
My name is Shannon Caldwell. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
Thank you. Counsel, you may ask.
Good afternoon. Ms. Caldwell, can you please state your position with the company?
Sure, I'm Director of Compensation.
And did you cause to be filed direct testimony and responses to data requests in this proceeding?
I did.
And do you have any corrections to your direct testimony?
I do have a correction to my direct testimony.
And can you explain what that correction is?
Yes, on page 22, row 1, starting with additionally, that entire sentence from row 1 through row 4 should be removed from the record.
Outside of that correction, if I were to ask you those same questions today, would your answers be the same?
It is.
And is it your intent that your testimony and data request be admitted into this proceeding?
Yes.
This witness is available for cross-examination.
Any cross?
No question.
No question.
Thanks, everyone. No. No? Okay. Any reason this witness couldn't be excused? Thank you, Ms. Caldwell. You're excused. And applicant, call your next witness.
Yes, Your Honor. At this time, we'd call Mark Arnold.
They're on their way. 8 minutes out.
We might,
He
take him
can
in the
come in the morning.
morning. Yeah.
If he's not here, we could just do Mr. Christie, and if he's here, or.
Are there questions for Ms. Hudson?
I do have a few for
Do you
Claire
want-
Hudson.
None
Yeah,
for Kira.
I do.
none for Kira.
I don't have any for Kira.
I have like 2 minutes of cross for Kira, and I think
I think I
may be
have
the
a few
only
for
one.
Kira as well.
Mr. Kira's here.
We had one tossed to him this morning, as I recall.
I think that's right.
Yeah.
But it's just, I have a very brief question.
Yeah. we can do, is Christie, do we have Christie here or,
Arnold.
Arnold?
They're on their way.
They're on their way. They were 2 miles away in our office in downtown.
Well, I'm
But I might
willing-
be able to get done with Kira in that time, if you want to. We have 15 minutes left. It's totally up to
It's,
you.
it's up to applicant. If you would like to go ahead and call another witness, we will.
We'll call Mr. Kira.
Good afternoon, Mr. Kira. Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Thank you. Please have a seat and tell us your full name and business address, please.
Yeah, my name is Ibrahim Kira. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
All right, Mr. Kira, did you cause testimony and responses to data requests to be filed in this proceeding?
Yes, I did.
And did you have any corrections or changes to any of those responses?
I do not.
And if you were asked those same questions here today, would your responses be the same?
Yes.
And is it your intent that this testimony and those responses be admitted into the record of this proceeding?
Yes.
Thank you. And I'm sorry, did you say your title?
No, not yet. So I'm principal load forecast analyst.
Thank you. Your Honor, the witness is available for cross-examination.
Okay. Attorney General's office.
No questions.
Okay, Mr.
No questions.
Kroger.
Thank you.
Yes, Ms. Grumman, I believe you have a few.
Just very briefly, good afternoon, Mr. Kira. Am I correct that you provided the load forecast for the future test year that's at issue in this case?
That's correct.
And the company, are you projecting load growth in the service territory?
The load mostly remains flat in the forecasted years.
Okay. That's all the questions that I had.
Staff?
No question.
Load forecast hasn't changed from the IRP forecast that you
Yep,
provided.
it's exactly the same one.
Just, it was slightly revised for 5 years to 0.1% expectation, is that right? Yeah, for, well, projected rate of growth, I guess,
Yeah, so,
for the 5 years.
I'm not sure which figure you're looking at, but my understanding is that this load forecast is the same as the one used in the IRP.
Okay.
Same numbers, same methodology, same everything.
Okay. And even though it feels like the weather is crazy every day, we're sticking to the NOAA's rolling 30 years and don't see any reason that we should deviate from that at this point.
That's correct. As a matter of fact, while I was preparing for this hearing, I was looking at how the 2024 actuals performed compared to what we forecasted, and they were spot on with respect to variance. And then I also looked at how the 2025 was trending. That was also aligned with what we had forecasted.
Slight warming trend, but nothing that, so in several of our cases, we've talked about maybe shortening that time period of 30 years just to adjust for volatility. You don't see a need for that at this time?
No, not at this time. So when you look at, energy, for the, for the entire year, adjusting weather normal methodology has, impact obviously in the summer months because it's getting warmer, but also in the winter months, it's getting warmer in the winter too. So when we conducted, and I'm just recalling based off of memory a while back, 2 years back, the total energy in a given year was offset based off of the increase in load that we were getting from changing normal weather methodology to account for increasing warming trend.
Okay. That's all the questions I have. Redirect?
No redirect, thank you, Your Honor.
All right, in that case, no recross. And any reason this witness shouldn't be excused? Okay, thank you, Mr. Kerr.
Thank you.
I'm okay with closing 10 minutes early unless we have them,
Well, they should, my text says they'll be here in 2 minutes.
let's give them 2.
Okay, thank you.
To save them from coming back tomorrow, both of them?
Yes,
So it's Christie and Arnold?
yes.
Okay. You had them stashed somewhere fairly close, it sounds.
Yeah, I mean, you can, do you just want to run these stuff? It's just nice to call it up.
Yeah.
I just saw, I looked over and I was on the first thing, I was like, what's going on? It's like literally, I looked up and all I saw was the air. And I was like, just caught the corner of my eye. I'm like, why?
During the conference call.
Yeah, no,
Settle down. I'm serious, why y'all?
I mentioned John that it might be after 3 days, sort of. I forgot to mention why, because before. Closing.
Yeah.
We do think like they end up doing their own class that goes in a cost of service study eventually.
Let's go off the record just a few minutes till our witness arrives. On the record, there we go. All right, thanks everyone. We are back on the record in case number 2024-00354. And counsel, please call your next witness.
Your Honor, Duke Energy Kentucky would like to call Mark Arnold to the stand.
Mr. Arnold, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please have a seat. And tell us your full name and business address, please.
Yes. Mark W. Arnold. Business address is 1262 Cox Road, Erlanger, Kentucky 41018.
Okay, counsel, you may ask.
Thank you, Your Honor. Mr. Arnold, could you give your title, please?
Yes, so title is Vice President of Zone Operations for Duke Energy.
Thank you. And did you cause testimony and responses to data requests to be submitted in this proceeding?
I did.
And do you have any corrections or changes to those responses
I do not.
or the testimony?
I do not.
And if you were asked the same questions this afternoon, would your responses be the same?
It would.
And is it your intent that the testimony and the responses be admitted into the record of this proceeding?
It is.
Thank you. Your Honor, the witness is available for cross-examination.
Any cross-examination?
No questions.
Okay. Any reason this witness couldn't be excused? Thank you, sir, for coming in.
Thank you.
You're excused. And if you have another one available, please feel free to call.
Thank you, Your Honor. Duke Energy Kentucky would like to call Thomas T.K. Christie to stand.
Mr. Christie, how are you? Please raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please have a seat. Tell us your full name and your business address.
Thomas Christie, go by TK. Business address is 100 South Mill Road, Noblesville, Indiana, 46062.
Okay, thanks, counsel.
Mr. Christie, could you please give your title?
Yes, Director of Transmission and Distribution Vegetation Management for the Midwest.
Thank you. And Mr. Christie, did you cause testimony and responses to data requests to be filed in this proceeding?
Yes.
And do you have any corrections or changes to any of the testimony or responses?
I do not.
And if you were asked the same questions here this afternoon, would your responses be the same?
Yes.
Thank you. And is it your intent that the testimony and the responses be admitted into the record of this proceeding?
Yes.
Thank you. Your Honor, the witness is available for cross-examination.
Thank you. Any cross?
No questions.
Okay. Thank you, sir, for coming in. You're excused. And with that, I will see everyone back in the morning at 9 a.m. Thanks for coming.